this case, I've seen the records, the service is not complete in respect of, service is not complete. So let the matter come after 2 weeks. I've taken consent from the cooperative bank. Bidding issue.
Service upon whom is not complete?
Seven and one also. Finance department.
One is what is the
Finance.
finance department? What is the requirement of service being complete? They have a standing consent.
The seven.
Who's seven?
Seven is the branch managers, some cooperatives in bank, rural development bank. In
We let the matter reach.
Good night.
Mrs. Sarkar, let the matter reach. If you have a difficulty for adjournment, you can pray for an adjournment. But for those matters, we will not like to call for a file at this stage of an order matter and check the file. We'll have it at the time when the matter reaches. If you have some difficulty in the matter, you can grant you an adjournment. That's not an issue. Yes, that's a different matter.
That's it.
On the prayer of Sri H.A. Sarkar, learned counsel for the petitioner, place this matter immediately after the BU vacation. The other side has been informed.
Yes, ma'am.
There are private respondents also.
Bidding issue.
Means no BD Goswami, yes, and for respondent number 3, R. Jalan is there. He's been informed or not?
Bidding issue, I've informed bidding.
He is for 12.
Yeah.
For 3, Jalan is there. When today we have got a matter listed out of turn because it was adjourned without information. I can tell you that. You try to have his, we have passed the order, but inform him before you leave. Okay, next.
So item number 47 and 48, Lordship. In this matter, I was being asked with supplementary list, sir.
Yes.
I was being with 1 week's time was granted, Lordship. My officer was in Gonutsav. Only today he has come up.
47, 48 motion matter.
Motion matters.
And from the other side.
Yes, he's there, Lordship.
Yes, what do you want?
On 28th or any date, Lordship, immediately after vacation.
On the prayer of Sri Sharma P. Sharma, learned standing counsel, AFDC matter stand adjourned to be listed on
21st or to any date, Lordship, after vacation.
21st of April, yes, 21st.
Interim order may continue.
47 and 48.
Interim order may
Yes, 21st April. Interim order passed till list is extended till the next day of listening.
Highly obliged, Lordship.
Malat, I beg to mention item number
47,
22.
48. Oh, so only 47. Yeah, for Mr. Sharma? 47 only,
47.
not 48.
No.
48 is
There was a week, Lordship.
No,
I'm
which is
mistaken.
the IA?
I, Lordship, I'm mistaken, Lordship.
47. Okay. Yes.
Malat, I beg to mention item number 22, Malat. As Lordship of judgment is there, Malat. Matter may be taken up today, Malat.
22.
Yes, Malat.
Which is the matter?
And this is regarding DMARC without any proceeding.
We'll take it up.
Item 22.
We'll take it up. What is the
Yes,
problem?
Malat.
May I please, Your Lordship. I beg to mention item number 46, my lord.
Yes.
The petitioner, my lord, do not want to praise this petition, my lord.
Last matter of the main list.
Yes, my lord.
Sri R. Sharma, learned counsel for the petitioner submits.
Housing.
That there is instructions not to press this application. Full stop. Also heard Sri N. Goswami, learned G. Assam, para. Petition stands dismissed as not pressed.
Obliged, my lord.
Was there any interim order?
Interim order, my lord.
Interim order, if any, stands vacated. Yes,
May please, Your Lord. Your Lordship, I pray for listing of a matter.
vote number 4. Vote 4, yes.
Lordship,
Obliged.
I'd like to mention item number 61 of the supplementary list.
Supply list, yes.
Yes, Lordship, in effect, it is an application for implementation and clarification of an order passed by a Lordship.
Hmm.
There is some urgency on our part, Your Lordship. Otherwise, these applications are taken up after motion matters. May I pray that this matter be taken up after motion matters?
61. What is the IA for?
IA is for implementation and clarification of an order, Your Lordship.
Clarification. What kind of clarification?
Lordship, the petitioner, Your Lordship, who had filed the petition, he had participated in the tender process where 2 kinds of maize seeds were sought to be procured. He had only participated for 1 kind of seed, Your Lordship. But while
We are not upgrading this matter. We don't find your conduct of the officer.
Lordship, I am appearing for the private party, Your Lordship.
We do not know. We are not taking this matter. No, out of turn. In fact, we might issue, draw up so motor proceedings in
In
the
fact,
contempt proceedings.
some developments have taken place which need to
We
be
will not
brought
know.
up for lordship.
We will not know.
Because in
There
spite
was
of that
interim order, some officer has acted very smart.
Now what they have done, your lordship.
We
in
want to
fact-
check how smart is the officer.
No, just one aspect, your lordship. What they have done
we
now,
are not-
it's
sorry.
not for that, your lordship.
We are not hearing now.
No, what they have done, your lordship, is
We are not hearing now, Mr. Pathak. We'll hear when the matter reaches. Yes, next.
Can I apply for a listing of a matter, my lord?
Code 4.
Eviction matter, my lord.
Code 4, all matter mentions code 4.
Lordship, the concern from other side, I beg to mention item number 19 and 20. As my senior Mr. NMB Chaudhary is out of station. Kindly the matter may be taken after the vacation.
19 and 20.
Yes, my lord.
And from the other side.
Yes.
I am appearing from 19, lord.
Oh, and 20?
20, Mr. H. Nath.
20 government. You are there, Mr.
AGCL is there, lord. AGCL.
20, AGCL. AGCL, you are there?
No, I am for the private respondent in item.
AGCL, you have informed the AGCL?
Yes.
Okay.
Lordship.
Item 19 and 20, it is submitted. Anna, on a mention made on behalf of the petitioner, matter stands adjourned by 2 weeks?
2 weeks.
2 weeks, 19, 20. Yes,
My lord, I beg to mention item number 6 and 7, my lord.
yes,
Kindly matter adjourned for the day, my lord.
6 and 7. These matters were fixed today for your
Yes, my lord,
instructions.
I have to bring some instruction, my lord, from the party.
On the prayer of Sri N. Ahmed, further 2 weeks time is granted to enable him to seek instructions, 6 and 7.
Obliged, my lord.
May it please, your lordship, I beg to mention item number 8. I have taken the consent of the other side. Let the matter may come after due vacation, my lord.
You have taken the consent of private respondent, 11 to 14.
Private-
What is there in this matter, madam?
We have to take some instruction.
What
Let the matter
instruction?
come
There is nothing in this matter.
After due vacation, my lord.
Lordship, kindly date may be fixed. I am paying for respondent number.
A prayer for adjournment has been made on behalf of the petitioner. Para, this matter was heard on 2 occasions earlier when this court had expressed the opinion that there is that does not see that does not appear to be any cause of action. What's the para? However, today a prayer for adjournment has been made. Full stop. Para, in the interest of justice, list on 19th, madam.
Obliged.
May it please your lordship, lordship, I beg to mention item number 10, lordship. This matter has been infructuous, lordship. Lordship, price bid has already opened, lordship.
Your name?
M. Alam, lordship.
Mehboob Alam.
Yeah, lordship.
On the prayer of Sri Mehboob Alam, on the prayer now, on Sri Mehboob Alam, learned counsel for the petitioner submits that due to subsequent development, the writ petition has become infructuous.
I put 1 to 5, lordship.
FCI, have you informed FCI?
No, lordship.
We can record the name. Sri M. Goswami, learned and Goswami learned State Council appears for respondent was 1 to 5.
5.
Whereas FCI, who is the PK Roy or BK Singh? BK Singh. দুটা নাম লিখি থব হা কমপ্লিট কৰি যো নাহে PK Roy is present for the FCI. Full stop. Writ petition is accordingly dismissed as infructuous.
Highly obliged.
Item number 13, basically, lordship.
Yes,
So this matter is doing by Mr. Ed Today, lordship, but it's not well today, lordship.
okay.
Matter may come after due vacation, lordship.
On a prayer made on behalf of the petitioner, matter stands adjourned by 2 weeks. Yes,
May it please, my lord. My lord, in item number 24,
Hmm.
we on behalf of the petitioners have filed an additional affidavit today, my lord.
yes, bring it.
May I pray that may be
Yes.
brought in accord.
I beg to mention item number 41, lordship. Correction of first matter, lordship. May I pray that the matter may kindly be taken up by 2, lordship.
Item number,
41, lordship.
we cannot assure if it reaches before lunch, we'll have it at 2, otherwise there's no upgradation.
May it please your lordship. It's regarding item number 1. On
Yes.
behalf of Mr. M.K. Pora, a little accommodation is needed, lordship. Can we matter taken up 2, your lordship? He is having some difficulties.
Okay, we'll have it at 2 o'clock.
1 and 2.
1 and 2. 1 and 2.
One is connected.
Is correct.
Madam Hazarika is here? No. She is in item number 2. What is the RFA? Are you there in this matter? No.
RFA, I'm one of the counsel in the RFA, Your Lordship.
Yes, yes.
RFA is regarding there is a compromise settlement has been initiated.
Connected with the main petition. Okay.
Also, this matter with regard to the dispute with regard to 2, 3 districts. So in fact, a joint verification has been done, and from the joint verification, it has been found out that the inter-district boundary line, it comes in the in between the river column. So a joint verification report has been submitted, and the circle officer has also demarcated the areas which fall under what district. So I have the report with me.
Let them file an affidavit, Your Lordship. We'll also have a copy of that.
Yeah, if the demarcation exercise has been done,
Yes.
what remains to be
There is
adjudicated?
nothing.
No, Your Lordship, only saying Your Lordship may fix it immediately on reopening, Your Lordship. In the meantime, we will also go through that report.
Heard Botapur, learned counsel for the. In both the cases, he was there. He
Not
was,
by my-
for the petitioners at one order. Para 3, as Barua, learned state council, however, submits that the demarcation exercise has been completed and a report has been prepared, whereby a report has been prepared, full stop. Sri Barua prays for some time to put the report on record by way of an affidavit, full stop. That this matter be listed on. We'll have it on 21st. Can you do it? No, 21st is Bihu vacation, it's not there. Not possible.
Let it be in the subsequent week, any day.
We'll have it on 8th of May.
Lordship, 8 of
Yes.
Or it will be too long. 8th May.
Yeah, yes.
8th May.
Deeply approved. Wait, please, Your Lordship. The respondent authorities, my lord.
You have filed the affidavit.
My lord, that is, my lord, we'll file it, I've got the inspection. My lord, in case of all the 3, my lord, issue, work, my lord, NID was issued. But in 2, my lord, it was not published in the newspaper. Because the work was below, my lord, 50 lakhs. There is an instruction in the sanction itself that, my lord, for e-procurement or e-tendering, my lord, below 50 lakhs is not required, but above that is required.
In paper.
Yes.
Otherwise, there is
They have
in the portal it was
they have
there.
handed in the official notice board, office notice board.
What about the e-portal?
E-portal, my lord, there's a e-procurement, my lord.
No, what about the, what was it there in the net?
In one work, my lord, e-portal, my lord, yes, we have uploaded
one
it
work.
in the, yes, e-portal. But I'll file my affidavit, let it come.
You
for
file an
review.
affidavit.
Yes.
Yes, that is necessary.
On the prayer of Sri B. Gogoi, Learned Standing Council, PWD, further time of 2 weeks is granted to enable him to file the affidavit in opposition.
Can it take me?
List on, tell us the date, Mr. Hope.
My lord, immediately after, my lord, Bihu.
List on 28th of April, is it okay?
Yes.
28.
Oblige.
24.
Oblige, my lord.
My lord, in this matter, I'm led by the additional AG. If it may please be passed over for the time being, he's on legs.
Kazi matter. Kazi
Yes,
matter.
my lord, yes.
Mr. Singh, because we have recorded your name. One matter has been it has been dismissed as infructuous. Okay. PK Roy Nadiba, PK Singh Diba. Yes. Got the instructions?
No, no.
Get the instructions.
My lord, last, on first date, you have told that this matter is very serious.
But in last 2 days, I don't think that matter is that serious taken by the government. My lord, only, let me complete. My lord, only 2 numbers of files are there. One with the political department and one with the director vigilance anti-corruption. If these 2 file records have been called to this court.
What is your name?
My name Vikash Bucha, my lord. I am the.
Mr. Bucha, you are appearing in person. We are giving you an extra privilege.
Yes, my lord.
But there is a process of the court.
Oh, my lord.
You do not remind this court about the seriousness of matters. We are aware
Yes,
the matter is serious.
yes, my lord.
Granting them an extra day's time is not something exceptional. Okay,
Okay, my lord.
you're in person, you're getting a privilege. We'll give you that privilege. But we have to do in terms of the order of the court, okay? Yes, but file is soon.
Good.
2 weeks.
Good.
Because Buksha, petitioner in person is present. And Gusam Learned State Council prays for further time to have the instructions. Full stop. Para, in the interest of justice, matter stand adjourned by 2 weeks to be listed on. We'll fix a date to enable you to appear. To be listed on. Yes, when?
On 25th, my lord.
On 26th.
26th.
26th, Wednesday. Okay.
Private respondent is also party, notice is required.
No, we have to issue notice. You get the instructions. If we, on perusal of the instructions, if you think that there's a matter for examination, we'll issue notice to him.
Thank you, ma'am.
26th. 26th vote.
Last occasion I was directed to produce.
The
the
status.
report. Yes, your lordship. I have received a communication from the circle officer, Guwahati Revenue Circle, your lordship. He has said that he requires some more days for verification of the records. So lordship, this is.
Okay,
Yes.
we'll grant you some time.
Yes, your lordship.
MSN Board Learned Standing Council, Revenue Department, prays for and is granted further time of 2 weeks. Is it enough?
Yes, your lordship.
2 weeks to get the instructions in terms of the order dated 27/3/2023. We fix a date.
Yes, your lordship.
Let the matter be listed on 28th of
28th.
April, 28.
Yes, sir. I'm deeply aware.
My lord, in this case, I have finally, my lord, affidavit, my lord, at 2, my lord. Finally, my lord.
Has it come?
My lord.
Has it come?
My lord, that will come, my lord. It is filing, my lord, going on. The urgency is here, my lord. I have annexed, I have handled documents, my lord. That to be, my lord, we have to produce by the lord.
No, we have to see the affidavit.
That is why, my lord, I have 2, my lord.
We have to see the affidavit before you. Let me list it day after tomorrow. You ensure that the affidavit is on record, okay? Have you filed it or are you going to file it today?
So it will being filed, my lord.
Uh,
Already start the copy, my lord.
Sri P. Mahanta, Learned Counsel for the petitioner submits that a reply, rejoinder affidavit.
Yeah, their rejection order, I have, my lord, in that.
An affidavit is being filed today with regard to the order by which the prayer of the petitioners have been rejected. Full stop. List, list this case.
Tomorrow, my lord, my lord. Because day after tomorrow, that will be hectic, my lord. So tomorrow it will be. I will bring these all the record, my lord.
No, if you file it today, it will not be on record.
But I can bring to the record, my lord.
But you ensure that the matter is it's tagged today itself, not tomorrow. If it is brought to the court tomorrow, we will not be able to take up.
No, my lord.
Will you be able to take the your affidavit today with the records today?
I can take my.
Tomorrow, last one. Be listed again tomorrow, date to the.
No, sir.
Yes. Item 50. Mr. Bothakur,
Yes, sir, Lordship.
Mr. S. Bothakur. None appears for the petitioner on call. Whereas Sri N. Goswami, Learned State Council as well as MSN Board Law, Learned Standing Council Revenue are present. In the interest of justice, please Dr. Ravi. Yes, last occasion, mention was made, but
Yes, someone, we
no,
are not
restaurant
there.
number 6 was not informed.
That's why, my
We
lord.
had to revise the order. Yes,
Now-
restaurant number 6, Mr. Mazumdar, what do you say?
My lord. Yes, sir.
Because they wanted time to file the affidavit.
Lordship, I could just like to say, what about the writ and how am I infected with this one?
Now,
Actually?
have you filed your affidavit?
Lordship, no. Lordship, I was not instructed to do so actually.
You have not filed your affidavit.
No, not yet right now. I was not, this is my first appearance over here actually.
No, that
In
is
this
it.
matter.
If you want to make some submissions, it has to be on the basis of some pleadings. You have not even offered your pleadings to the court.
So,
We have changed the date on your request because you are not informed.
yes, yes.
Unless you make out some exceptional case,
Not severe.
otherwise you would have taken the same, availed the same benefit of filing an affidavit in the meantime.
Lordship, I can argue on this matter, this thing actually, what is my client is going through. So,
If your argument is based only on the pleadings of the presently available, you are free to do so. But if you want to rely on anything, we will not be allowed to do.
Shorted them, no? Lordship, a shorted.
We had given two,
But the
weeks
thing
time.
is that holidays are approaching actually. So my Lordship, I want to argue the matters on this matter itself actually. May I?
If you want to raise a point of maintainability, that we can grant you the first audience. Otherwise, Mr. Mr. Barbara, senior counsel is the petitioner. We have to hear him first. We have to go by some order. You cannot just barge in and say that I want to say something.
He has just filed a wakalatnama, no pleading.
You can still argue on the maintainability issue or anything raising objection on the some preliminary grounds, but otherwise you will only respond to him. We may not be satisfied with their argument. We may.
Then Lordship, I could pray that a short date may be given actually, my Lordship.
Mr. Mazumdar, this matter has been listed only because at your instance.
Yes, my Lordship.
If you make a mention, we understand that you was not informed,
Yes,
but
my
you could have seen the practical aspect. You take the same time, you file your affidavit. But not because of again on the case, only for the sake of formality.
Okay, my Lordship, I will file.
We'll have it after 2 weeks. You exchange your affidavit. Okay.
Problem.
A prayer has been made on behalf of the respondents for time to file the affidavit in opposition, full stop. Let this matter be listed after 2 weeks to enable both the FCI and the private respondents represented, both the FCI represented by Sri P.K. Roy, senior counsel, as well as the private respondent number 6, represented by Sri I.S. Mazumdar, to file the affidavit in opposition.
Any affidavit he files, my lord, I am entitled to file.
Sri A.C. Barbara, senior counsel for the petitioner, submits that rejoinder affidavit may also be filed in the meantime. Full stop. It is needless to state.
I will not file a rejoinder. In case any pleading filed by them, I am entitled to file a reply. That's what I am.
That is only. It is needless to state that it is the liberty of the petitioner to file rejoinder if so advised.
This matter relates to non-payment of ex gratia lump sum payment in favor of the petitioner.
My
Is the widow of late Raman Kumar Lordship, who was
Now, what is the scheme?
Lordship, he died on duty, Lordship, and there is an office memorandum under which she can get lump sum compensation, Lordship.
5 lakhs. 5 lakhs.
Yes, Lord.
He died as what?
He died as an operator of excavator machine, Lord.
In where, working where?
He was working, Lordship, in
Border
under grave, Lordship.
grave.
Mr. Parashar, you have not filed your affidavit.
Well, affidavit file, my lord.
Oh, you filed it?
File on 14 to.
Yes, yes. we have got. So, you need to, or you,
Though this is a matter, my lord, I am just, though I have to go by the, then in the affidavit, my lord. He was on leave. He went to join his duty.
join his duties.
Join his duty. He reported in the base unit. His unit is far high. When he went in the departmental vehicle, from the base unit, in the meantime, there is a landslide. And another excavator was working for removing the road melon, clearing the road melon. And that driver was his friend. That petitioner went to help that driver. And he operate the
Excavator.
excavator also for some time. Subsequently, when he came back to the bus, suddenly he slipped down and he fell down and died. So basically, our stand in the affidavit is that he was not on duty because though his unit is reported only on the base unit, that is our stand. But I am saying in such type of cases, on 10/5/22, this another court already taken a view. That's he is your person, and there are several subsequent judgments that when a person went by his scooter on judgment to his workplace, even in not reach the office, but that in that case also
He was given the ex gratia.
in another department, but that was the one case. So, though of the record, I have to go by the affidavit.
That we appreciate.
That is the stand, only. And yes, he was not actual duty, but he is a border person, and he went from the base unit to the his unit. During this, suddenly this incident happened.
Where was his actual posting?
He was proceeded to his unit 151 FCPL under incident on he rejoined on duty on 28th of December 2002 and incident of
The next one, Lordship, kindly peruse, Lordship, the unit name is there at the initial portion, Lordship. Page 14. Raman Kumar, serial number 4.
But the incident was the 1st of January 2003.
Lordship.
yes.
He rejoined on 28/12/2002, Lordship.
No, the incident is of 2003. When did you file the writ petition?
Lordship,
In
in
19.
2019, Lordship.
Why this delay?
Lordship, she is a widow, Lordship, and probably she didn't have that much.
No, we have all the sympathies for a widow, but she was a widow in 2003, she is a widow in 2019.
Maybe, Lordship, but then
1 year, 2 years, 3 years, 4 years, we can understand. 16 years. What explanation have you given?
Lordship,
We preferred representations before the authority.
That is not going to help.
Page 34, Lordship may kindly peruse, Lordship. The compensation due to her was denied. Page 34. It's of 29/1/2016, Lord.
Okay. They were adjudicating the matter
Not on government.
and they had denied.
Not on government bona fide duty, that is the,
Then it is okay.
yes.
But simple representation would not have helped your case unless there is some acknowledgement by them or rejection. Heard. Three, MP Sharma. Learned counsel for the petitioner. Also heard. Three. A.K. Parashar. Learned CGC
For all.
for all the respondents. Full stop. Considering the nature of the case and as agreed to by the parties, comma, this writ petition is taken up for disposal at the admission stage, full stop. This court has also taken note of the fact that the contesting respondents have filed an affidavit in opposition on 14/2/2020. Full stop, Tara. The projected case is that the husband of the petitioner, have you seen, please? Husband of the petitioner, Sri Raman Kumar, was appointed as a General Reserve Engineering Force. Appointed in the General Reserve Engineering Force as what?
As operator of excavator machine, Lord.
As operator of excavator. Such appointment was in May 1999. Full stop. On 28/12/2002, comma, after rejoining his duties, comma, the husband of the petitioner was proceeding to his place unit of posting, namely 112 RCC in the department vehicle. And on the way, there was a massive landslide. Full stop. The husband was instrumental in operating the excavator in duty and helped in clearing the landslide. And in the process, and immediately thereafter, on the same date, he met with an accident and passed away. But full stop. The petitioner's case is that there is an office memorandum dated 11/9/1998 by which ex gratia lump sum amount is payable in such case, and accordingly, the petitioner filed an application for such release of ex gratia payment, full stop. However, comma, her case was rejected by a communication dated 29/1/2016. Full stop. It is by this action by which the petitioner is aggrieved and has approached this court for a direction to release the ex gratia payment in terms of the OM dated 29/1/2016. Full stop. Sri Sharma, the learned counsel for the petitioner, has submitted that a hyper-technical approach has been taken by the authorities in denying the entitlement, which is against the aims and object of the scheme. Full stop. He submits that there is no dispute to the fact that the husband of the petitioner had expired while he was on duty, and only because he was approaching to his unit in a department vehicle and had also rendered his services in clearing the landslide which had occurred on the way. Full stop. Para. Sri Parashar, the learned CGC, has submitted that the stand of the respondents have been put in the affidavit in opposition filed on 14/2/2020. Full stop. By referring to the communication dated 29/1/2016, comma, the learned CGC submits that as per the clause of the office memorandum, comma, the death has to occur due to accident in the course of performance of duties. And in this case, comma, the accident had occurred while the petitioner, the husband of the petitioner, was not essentially performing his duties. Full stop. Should we record the other submission or concession? No.
No, that's fine.
Para. The rival submissions of the learned counsel for the parties have been duly considered, and the materials placed before this court have been carefully examined. Full stop. Para. Where is the office memorandum?
Lordship will peruse page 25.
24.
It starts from 24. Page 25, paragraph 5.
No, that is the amount.
Okay.
We are not on the amount. The office memorandum in question is on the subject of payment of ex gratia lump sum compensation to the families of central government civilian employees who die in harness, and includes the recommendation of the 5th Central Pay Commission. Full stop. The rejection of the prayer of the petitioner is on the ground that the death has not occurred while the petitioner was performing his duty, while the deceased was performing his duties. Full stop. However, comma, the objective and objective and the aim of the scheme appears to give certain benefits to the bereaved family of a central government civilian employee who die in harness. Full stop. In the instant case, comma, admittedly, the death has occurred when the husband of the petitioner was proceeding to his place of posting, unit of posting in a department vehicle, and on the way had also rendered his service by operating the excavator and assisting the operator of the same in removing the landslide. Only a full stop. Only thereafter, comma, the accident had occurred, causing his death. Full stop. Under such circumstances, comma, denying the ex gratia by taking a hyper-technical objection does not appear to be in consonance with the office memorandum holding the field. Full stop. In their view of the matter, comma, this court is of the opinion that the benefit of the OM for payment of ex gratia cannot be denied to the petitioner, who is admittedly the widow of a central government civilian employee. Full stop. As per paragraph 5 of the office memorandum in question, comma, the amount specified in case of death is 5 lakhs. Full stop. In that view of the matter, comma, this writ petition stands allowed by directing release of the aforesaid amount to the petitioner in terms of the office memorandum expeditiously, and preferably within an outer limit of 2 months from today. Full stop. Writ petition stands disposed of.
Lordship, may I pray one thing, Lordship? Since the date occurred in 2004, itself, 2002, Lordship. After that, Lordship, amendments to the office memorandum has also been done, Lordship. Since the consideration or rejection of the petitioner's case was only in 2016, Lordship, by then the government has already implemented the recommendation of the 7th pay
So
commission.
we'll have to see from the perspective when the accident had occurred.
Yes.
Lordship, that is true, Lordship. That's why I did not place the office memorandum, Lordship. But then, Lordship, some interest as per bank norms may kindly be granted, Lordship.
Interested in ex gratia, interested is
Because it was on the fault of.
understood, but not in ex gratia. Ex gratia is something which is out of grace.
And Malak, she already got the pension and all other benefits she already got.
And that is okay, but this is of her entitlement. Release it to her.
Malak, that.
Okay, next.
Right, Lordship.
Sixteen.
May I please, Lordship? I am put a response 6 and 7, Lordship. IOCL.
Find your affidavit.
No, not actually.
You filed your affidavit.
Yes, Lordship. This one I absent on last 2 occasions, Lordship. They have basically challenged the demand, show cause notice issued by the government, Deputy Commissioner, Lordship, for service tax.
Who's the petitioner? None appears for the petitioner on call, whereas 3 and Gussamil and the State Council, as well as K. Kulita, present council for the IOCL,
Yes, Lordship. 6 and 7.
are present, full stop. On the previous
6/11 and 17/11.
2 occasions also, none had appeared for the petitioner. Petitioners. Petitioners.
3 occasions, Lordship.
How many petitioners are there?
Last order reflects earlier 2 occasions.
Understood. How many petitioners are there? 1 or 2?
1, Lordship.
For the petitioners I have. repetition. On the last two occasions also, none had appeared for the petitioner. Full stop para. List again on day after tomorrow. It is made clear that in case of further non-appearance, non-representation, comma, this court may pass appropriate orders. This court would pass appropriate orders.
Obviously.
No,
17. C made he as not, none. None appears for the petitioner on call, whereas Priyan Goswami, Planet State Council is present, along with Sri A. Bhattacharjee, and Standing Council Revenue, full stop. On the previous occasion, also, none had appeared, and this court had observed that in case of further non-appearance, comma, appropriate orders will be passed, full stop para. It seems that the petitioners are not interested to prosecute this matter, full stop para. In view of the above, the writ petition stands dismissed for non-prosecution. Yes.
Last occasion, Lordship, it respondent
Affidavit filed.
question.
Here for whom?
Lordship, I am for the Higher Education Department. The respondent number 3 appeared on the last occasion, Lordship. But today, Lordship, his presence was not.
Today he has not appeared.
Lordship. He sought for 3 weeks' time to file the affidavit.
Yes, what steps are you going to take against this kind of conduct? Have you seen the explanation why he was not appearing?
Yes, Lordship, I've seen.
Only because IC was
In charge.
written.
In charge was not.
Can that be an explanation? Yes, that will be an explanation if you go strictly technically, but if he is technical, we can be more technical.
Yes, Lordship.
We can have his personal appearance on his day. Make him sit from 10:30 to 3:30. This is not some ego issue.
And Lordship, the entire work order was issued by him, Lordship.
No, we are not on the
So,
merits of the
Lordship,
case.
his
We are on the
presence is-
conduct of respondent number 3.
Yes, Lordship. His presence is required, Lordship. Respondent principal. Personal.
Personal appearance.
Day after.
Fix a date, Lordship.
We have it day after tomorrow.
Yes, Lordship.
You, in the meantime, you try to inform him.
Yes, Lordship.
If he is here, well and good. Otherwise, we know how to deal with persons of this nature. This matter, which was filed in the year 2022, is pending mainly for the purpose, mainly on the issue of service and appearance of the respondent number 3. Full stop. In fact, this court, by the order dated 19/12/2022, had directed personal appearance of the respondent number 3 as the office notes indicated that notices were in fact served upon him. This court had accordingly fixed 30/1/2023 as the date of appearance. Fourth of para. On 31/2023, comma, the respondent number 3 did not appear. First of, however, taking into consideration that there was some delay by the registry in serving the notice upon the said respondent number 3 for his personal appearance, comma, benefit of doubt was given to him and the next date was fixed on 19/12, on 13/3/2023, with a further direction to issue press notices, which were accordingly done. Full stop. Para. On 13/3/2023, the respondent number 3 had appeared in person, and the explanation given on the query for his non-appearance or failure to respond on the earlier occasions was that in the notice, insures was written after principal, whereas there is no principal in charge of the college, and he was the principal only, full stop. Though the aforesaid explanation was not at all convincing, comma, still giving the benefit of doubt to him, comma, this court, on his request, had granted time till today to file his response by way of an affidavit in opposition. Full stop. Today, when the matter, as indicated above, today was fixed on a request made by the state respondent number 3. Full stop. When the matter is taken up today, comma, neither the respondent number 3 is represented, nor any affidavit in opposition has been filed. Full stop. The conduct of the respondent number 3 appears to be one of overreaching the jurisdiction of the court and to circumvent the process. Full stop. Para. In that view of the matter, this court directs Sri Upamanyu, the learned Standing Council, Higher Education Department, to inform the state respondent number 3 about the matter, which is fixed again on day after tomorrow, on 12th of April, to enable him to represent. Full stop. On failure to do so, comma, this court would consider passing of appropriate orders. Full stop. Sarah, let a copy of this order be furnished to Sri Upamanyu during the course of the day.
Highly obliged.
Yeah, Mr. Malad, actually number 17, madam, I'm very sorry, Malad, I could not appear. Petitioner like to withdraw the matter, madam. So
17 to middle so already passed orders.
Malad, I was on second court number 1.
You should have someone. Huh? Okay. 17, okay. Who was there? Revenue, who was there,
Yes.
Mr. Bhattaji, you were there?
Yes, yes.
Yes, not. Learned counsel for the petitioner submits that there is instructions not to press this petition because of appearance in academia. And Kusam State, Aperture Cities Revenue. Represents accordingly stands dismissed on withdrawal.
Obliged.
So in this case, Lordship, the response number 2 has filed an affidavit. I want
Who's
to go
two?
My lordship.
Here for two?
Yes.
Who's two?
The Assam Skill Development Mission, your lordships.
They have withheld an amount of 2,09,000 lordship.
What is the subject matter?
Lordship, I am a lordship registered training partner lordship. Under the Assam Skill Development Mission, we have provided training, skill training to batch in batches. And out of total amount of rupees 5,97,000, they have paid an amount of 387
You said that you are entitled to the balance amount.
balance amount lordship.
What is who are you? You are the department or the authorities.
Your lordships, the mission, the Assam Skill Development Mission.
You will be releasing the amount.
Your lordships, I have reservations that you
No,
complete
no,
our address.
you are supposed to release the amount, which you say that you.
My lords, it's a contractual dispute. Then if you see the prayer and the.
We are not on that.
My
We
lord,
are not saying that you have to.
my lord,
You are the person from whom he is seeking the
my
release.
lord.
Anyone else? You have filed your affidavit.
Yes, my lord.
You filed some rejoinder.
This is a very voluminous lordship. I just want to go through that. Records.
When did you file the affidavit? 15/2.
15 to your lordship.
You need require some time, Mr. Das?
On March.
No, it was filed on 15/2.
Oh, in the March.
Into March? Your lordships, the first one was filed on 15/2, then there was an objection which was placed by the registry, which was removed on 15/3.
Okay, 15/3, okay. 15/3. How much time do you need, Mr. Das?
Immediately after BA vacation.
Okay. Like to file a rejoinder or what?
I'll go through it if required.
We said that we grant you time if you are advised, you can file a rejoinder. Your name?
K. Khanna, your lordship.
Heard three. This is item number
21.
S.K. Das, Learned Counsel for the petitioner. Also heard Sri K. Khanna for the respondent number 2, who submits that the affidavit in opposition has been filed on 15/3/2023. He further submits that the entitlement that the petitioner's prayer does not deserve any consideration, and otherwise also the dispute in question is a contractual dispute which cannot be the subject matter of adjudication in a writ proceeding. Full stop para. Sri Das, Learned Counsel for the petitioner, prays for some time to obtain instructions and file affidavit in reply if so advised. Full stop. List on. You are an obsession counsel,
My lords, I'm pretty much here now.
but if you want a date, we can give you a date.
My lords, any date can
Any
be.
conference that.
Tell us a date. After how many days?
Only objection is that we have not been able to place the engagement certificate of the passed out candidate.
How many days you
So we
need?
are trying to obtain those lordship certificates from the passed out.
We have it on
Employed lordship.
we have it on 8th of May.
Lordship.
Enough time, I think.
Lordship.
8th of
8th
May.
of May, very well done. Obliged.
There is no interim order, I suppose.
Lordship, already an amount has been released lordship,
Okay,
and lordship, the only the balance amount.
okay. Next. Mr. Das?
Lordship. In this case, my lord, petitioners are all by-party Indian citizen, but wrongly incorporated my lord D-mark. That is only grievance, my lord.
You wanted this matter to be taken up today.
No, lordship order is there, my lord. Matter to be directed.
We have reached by 11:30.
Oh.
You thought it will not reach.
Yes, yes. No, my lord.
Functions, the celebrations are over now. We are back on track.
Yes, my lord. Background fact, my lord, just I have to place, my lord. Today, my
Yes,
lord.
is it covered? Madam,
Yes, Lordship, Mr. Ali, he is on legs in another.
it doesn't matter. Is it covered?
It is covered.
You have a similar order.
Yes, my lord.
You
Lordship
make the
order.
corrections.
Lordship.
Make the corrections
I'll put-
and
It is
get
corrected,
it verified. Then you pass it over. Okay. Make the all corrections. Madam, you have a look. Name of the council also.
Yes, my lord. I'll-
Dispose of. Mr. Bora?
This is a challenge to a cancellation, GST cancellation. What I am
GST
relying on, they have taken time to file affidavit, they have not filed affidavit, but what I am on is at page 18, there is a notification. I seek the benefit of this notification, there are similar orders.
Yes, Mr. Chaudhary, what do you say?
Lordship, on the last occasion, in another case, Lordship has passed an order. Recently, the government has issued a circular.
That you have
extending-
adopted the central government.
Yes, Lordship.
Yes. That's on.
Lordship, formally, state government has also issued a letter, Lordship.
No, that day we have recorded
Yes,
the submission also.
It was in case number 75 of 23.
You have a similar order.
Yes.
Do you have a similar order?
Yes, Lordship, but earlier order,
Now, Lordship, this
799.
circular will cover, Lordship.
this
Okay,
755 of 2023 would cover.
okay.
At
Not
page
23.
18 is the notification.
Oh, yeah. The earlier order was in Padma Lakshmi.
Yes, Lordship.
Can you make the changes and we don't want to waste any further time. We pass the same order. Make the changes here. Give. It's based on the same notification of central government. Yes.
Lordship, the factual part, the rest of the last paragraphs will be similar, Lordship. Only the factual part.
Okay, I'm going to go on the.
Lordship, 7, 8, 9 will be similar, Lordship.
Even 6 and 7, we are not going to.
Yes, Lordship.
6 and 7, we are going to change it. Third, BP Bora, Senate Counsel for the petitioners. Petitioner. Also heard B. Chaudhary, Senate Standing Counsel, Finance, within bracket Taxation Department, Government of Assam. Para 2. Considering the subject matter in dispute and also the fact and also the development which had taken place in the meantime, this writ petition is taken up for disposal at the admission stage. Full stop. Para. The petitioner claims to be a contractor working for various departments of the government of Assam and he is registered under the Goods and Service Tax Act 2017 with registration number so and so 18 on 23/3/2021. Full stop. It is the case of the petitioner that he had defaulted in payment of tax for 6 months and accordingly on 16/11/2022 he was served with a show cause notice
20,
as to why
21, Lord. 11 to 20. Page 17. Lord.
Also, in the synopsis, it is different.
you have written 22
Sorry.
16/11/2021. He was served with a show cause notice as to why his GST registration should not be cancelled. Full stop. However, the information of such show cause notice, according to the petitioner, was received by him only in May 2022. And accordingly, he did not get adequate opportunity to reply to the said show cause notice. Full stop. On 30/11/2021, the cancellation order was issued, whereafter the petitioner had approached the GST authorities for revocation of the cancellation. Full stop. It is the case of the petitioner that he had offered to clear all the pending taxes with requisite penalties. Full stop. Since no action was taken on his request, comma, the instant writ petition has been filed. Full stop. Para Sri Bora, the learned counsel for the petitioner submits that the so-called notice was issued at the time of the pandemic, and only because of the reason that the petitioner was not informed about it, comma, he could not file the reply. Full stop. However, the bona fide of the petitioner is reflected by the fact that in his representation for revocation of the cancellation order, comma, he had made an offer to clear all the GST as well as requisite, all the pending taxes, as well as penalties, comma, if any. Full stop. Para. The Beach Authority, let us standing counsel GST, however, submits that this court may not be required to go into the merits of the case in view of a recent communication of the central government dated 31/3/2023. Full stop. That's the property, no? Paragraph 5 or pro. He further submits that the state government has subsequently issued a notification dated 4/4/2023, whereby the aforesaid office memorandum dated 31/3/2023 has been adopted, and liberty was granted to all such class of persons to apply for revocation of the cancellation of registration. Full stop. Eight to paragraph 8. Yes. Deeply obliged. Dispose of.
Lordship, in this case for respondent number 1, 2, and 3, SCKL name may be read.
Central.
Yes, Lordship.
They do not have any role.
Not a necessary party. But he has made a party.
Why have we made them party? Okay, SCKL for 1, 2, and 3. Standing counsel says CGST.
Yes.
Yes, next.
There is a tender for supply of liquid nitrogen. There are some further developments, madam. We are in the process of filing an additional affidavit. Can it be taken up day after tomorrow? It will be filed during the course of the day.
Additional affidavit for what purpose?
Some subsequent developments have taken place, which we have brought it on record.
Malak, a copy has been given to me sometime back. I have received it.
Day after tomorrow?
Day after tomorrow.
Day after tomorrow, we'll try to have it for disposal.
My lord.
Malak,
There's a stay order, I think.
I have
Either
the-
DC or that way.
yes, Malak, I have the
Yes.
record. Records I have.
Sri I. Chaudhary, London Senior Counsel submits that owing to certain developments, comma, an additional affidavit is being filed today. Full stop. Para. Considering the urgency expressed on behalf of the respondents, matter is directed to be listed on Wednesday dated reverse. Full stop. The affidavit that may be filed today be brought to the records.
Interim.
Interim order passed earlier. Hence extended till the next date of listing.
Right.
25.
That little lordship, in this case, instruction is waiting lordship. I pray for 3 weeks time.
What was this?
Blacklisting in violation of natural justice. Your lordship was pleased to.
Interim order is there?
There is an.
What is there lordship?
Sri R.K. Talukdar, Learned Standing Council, NHIDCL, prays for and is granted 3 weeks further time
Lordship.
to file the affidavit of opposition, full stop. Let, granted, interim order passed earlier stands extended till the next date of listing. Next,
Your lordship is fixing a date.
3 weeks. If you want a date, we can fix. Tell us the date after 3 weeks. List on the 8th of May.
8th. Right.
May I please, your lordship?
Yes.
The petitioner is aggrieved by the interim order whereby his GST registration was cancelled.
Yes.
This is a peculiar case, your lordship. Here, the petitioner go
State GST.
yes, your lordship.
We will not be covered by the notification.
Your lordship, I have already paid the tax, furnished the return under section 39. Only thing is that I didn't furnish the return under section 37. As such, my registration was cancelled. Thereafter, on 5th January 2023, that
Where is Mr. Chaudhary? State GST. He's not aware of this matter.
yes, your lordship, he took time last for instruction, your lordship.
Sri Chaudhary, he's there. Madam Bodloy. Good for a while. Yes, next. IOCL, yes.
Yes, they have filed an affidavit, lordship. I don't think we need to file a reply, man. Nothing new has come out. It's
Okay.
whatever is in the tender process, the tender notice will be there in the
Okay.
affidavit. Lordship, today the matter has been fixed for consideration of interim order, your lordship.
Yes, Mr. Bhardev.
Affidavit we have stated. To bring in the.
You are R5.
I'm responding 6, 7 and 8.
Oh, ho, ho. 6, 7, and 8. Let us have the affidavit on record. It's not here. When did you file?
The 6, 4, 2000.
6, 4, 6, 4, it should have been here. Sure, affidavit too. এখন আইছে R5. Who's 5? No, just তুমি চোৱা মই দেখা নাই তাত কেতিয়াবা নেলিখে যে R5 লিখা আছে বাহিৰত এই ফ্লেগ মৰা আছে এখন R5
DTO, my lord, DTO transport.
এই ফ্লেগখন পিংক ফ্লেগখন R5 এখন পিংকখন তাৰ তলত আছে নেকি নাই এইটো আৰু নাই ন কেতিয়াবা থাকে নাই নিদিয়ে নি let us have that. We can have it day after tomorrow, but day after tomorrow there may be some can have it tomorrow or day after when you see.
Your lordship, please.
Day after tomorrow, okay, we'll try. Day after tomorrow.
Tomorrow, if the lordship fix it.
Tomorrow it'll be, I think I'm thinking for your benefit. Tomorrow we can give some time. Day after tomorrow being the last date, again, there may be some. We'll have it tomorrow. The MK Chaudhary London Senior Council for the IOCL submits that the affidavit in opposition has been filed on 5/6/4.
We have received on 6/4.
6/4/2023, which however has not been tagged with the records. MSB Bhuya Senior Counsel for the petitioner submits. However, submits that copy has been served upon the learned counsel for the petition. What's the para? As agreed to by the parties, list again tomorrow for admission by taking the affidavit in opposition filed by the IOC. Tomorrow the date to deliver. Yes. Mr. Chaudhary, anything can be done?
Cannot go beyond the provisions of the guidelines.
You give us a handle, you may not go, we'll tell you how to go. But you tell us,
I was trying, my lord, but then
you tell us,
I don't think. my
will
lord,
not, it will be our words
with
and your
all-
thought.
All sympathies to the petitioner, perhaps, my lord, there do not see any route but to which.
No, this is a very exceptional kind of a case. Until now, we have not seen anything on records questioning the bona fide or raising any doubts on the bona fide.
That's
Only that is the only reason we are trying to explore any option by which
in the event, my lord, the transport department can transfer it, my lord, the things would be easier for us.
We are ready to give the undertaking, Worship. We're submitting a bond.
because ultimately the objective is whether justice is done or not.
Transport and explosives also, my lord, that aspect.
We are ready to, with the
Well, let me have
responsibility.
a
my lord.
discussion tomorrow, little bit after tomorrow.
Last working day, you know.
Day after tomorrow. No, there are not much cases. There are 2 bench for, so not an issue. Celebrations are over, so we are free.
One more day is there.
That is what we call Atmawala.
Yes.
Not too much of a headache. We have to go and have something there. Yes, day after tomorrow then. Tomorrow, no, day after, day to deliver. Please try to have some instructions. Mr. Goswami also. No, try to have some instructions, some via media, something can be done. Exceptional case, we'll say it's not not act as a precedent.
May I please, Lordship?
In this case, we have written starts with the admitted amount lordship.
Get the instruction, which department?
That's it.
Police department.
And they forward to the head office for financial sanction.
On the prayer of Sri N. Goswami, then the State Council matters can be done by 2 weeks.
Lordship.
2 weeks to enable him to get the instructions.
Machu.
Yes.
Lordship, I've communicated the letter, communicated the order, Lordship, to the department. I'm still awaiting instruction.
We can grant some time. On the prayer of MSN Bodloy, Learned Standing Council, Revenue Department matters can adjourn by 2 weeks to enable her to obtain the instructions.
Keep your pleasure.
Lordship
Yes.
will kindly take up the matter after the next matter, after 31, your Lordship. My senior is on his way, your Lordship. Court number 12.
That malt,
Yes,
what has happened now?
the Lordship had desired to get the results of the tender in a seal cover. But
Have
we
you got it?
We have instructions from.
Mr.
our-
Chaudhary is appearing.
Yes, he'll just be appearing in a while.
Okay, call him after a while.
Yes, yes. He'll just be here, your Lordship.
Yes. Yes, next.
Yes, you may kindly call up the next matter. Your Lordship.
9 ko nasil na. Timing asil nahi. Kazi matter. Mr. Mazumdar. Item 9, he's here. Yes, petitioner. Item 9 was time being passed over for the time being. Who was for the petitioner? Borbhuya, not Borbhuya. Borbhuya was not there. Yes, ARBO was, ARBO. No, where is his colleague? কোনে আহা বুলি ক'লে নাই নাই এওঁলোক আহিব লাগিব ন নাহা নাই ন No, in his absence will not be not look proper if you take up the matter. Time was passed over the matter for time for both of you.
Yes. I was on the
No, that's okay. Let him come. We'll have it when both of you are there. Is he around, Mr. A.R. Bhuya? Is he around or not? Where is his colleague? Okay. What was this matter? Just an overview.
It has been filed, challenging a notice issued by the.
What are the acts involved?
The prohibition of child marriage Act 2006, primarily, my lord, and the Assam Muslim Marriages and Divorce Registration Act 1935. In the writ petition, the challenge is basically a letter or a notice issued by the executive magistrate asking President MMR, he is MMR come Kazi, asking him to produce certain documents because there are complaints that he has registered marriages where the parties were minor. Now, as against that, when I find that he is mentioning that some criminal proceeding has been initiated against him, and police has also visited his place to arrest him. Now, if the cases are registered under a POCSO and also under the Assam Muslim Marriages and Divorce Act 1935, where also there are provisions to say that if the marriage takes place minor, then it amounts to a criminal offense.
A special marriage act.
Sorry, my lord.
No, doesn't matter. Now,
Lord, this is the matter, my lord, wherein my lordship is already heard, my lord.
We have this.
My lord. So, my lord, my case is that, my lord, I am a licensed.
We'll come back.
My lord.
If you remember correctly, his contention was that under the act in which he discharges his duties, he only registers, he does not solemnize the marriage. And that act has also made an observation regarding minors, which he indicates that it may not be an offense as such. Because it also has a provision if the bride and the bridegrooms are minors. So you just need to address on that.
May I please, your lordship? My lord, the petitioner before my lordship is the Muslim marriage registrar, my lord, in the district of Karimganj under the Nilam Bazar police station, my lord. My lord, as per the provisions of the my lord, the Assam Muslim Marriages and Divorce Registration Act of 1935, my lord, I had been given the license only to, my lord, register the Muslim marriages, my lord, if an application is made to me that the such marriages is required to be registered, my lord, then only after verification in accordance with the provisions laid down under the Act of 1935 as well as the rules, Lord, I can register, my lord. Now the, my lord, issue arises, my lordship is well aware, my lord, that the government by a policy decision in the cabinet on 23rd of January 2023, my lord, decided to stop the child marriages in the entire state, my lord. As a result, my lord, a massive crackdown has also been initiated by the Home Department, by the various police stations of the concerned districts, my lord.
As a result, my lord, what has happened, as I am a my lord Muslim marriage registrar, my lord, I am registering certain marriages. A notice had been issued addressed to the petitioner, my lord, which I have impugned in this petition and which my lordship may be pleased to find is at my lord page 69, my lord. Is the type copy, my lord, and the original is also I have annexed with my lord. May I read over, my lord? To Mr. So-and-so is the petitioner, my lord, subject notice, whereas the certain complaints have been received that you have been registering the marriages by violating the provisions of the Prohibition of the Child Marriages Act of 2006. Whereas there are prima facie evidences and documents produced before the undersigned that the early child marriages were registered by you, which attracts the panel action for the non-compliance of the provisions of the aforesaid act. Now, my lord, just pausing for a moment, my lord, they have said that I have registered by you, which attracts the panel action for non-compliance of the provisions of the aforesaid act. My lord, if we go by the prohibition of the Child Marriages Act, my lord, 2006, there is no panel provision has been assigned for the purpose of registration of the marriages, my lord. Now, again, my lord, you are therefore asked to appear at the office chamber of the undersigned, along with the all records, registers, etc., pertaining to the marriages registered by you during the year 2021 and 2022, with the specific particulars oblique records for registration in respect of the following cases on so and so without fail. So, my lord, they have particularly assigned these 4 numbers of my lord marriages which I had been registered, my lord. Now, responding to this notice, my lord, I did appear before the concerned officials, my lord, who issued the notice and produced all my records, my lord.
When did you appear?
My lord, I have appeared, I have stated, my lord, on the scheduled date, my lord, on the scheduled date on which they have, my lord, on 4/3/2023, my lord, I have appeared, my lord, and produced all my registers as well as the records which I am maintaining as a my lord Muslim marriage register in my office, my lord. Now, my lord, even after this, my lord, what has happened? The police of the Nilam Bazar police station, as per my instruction, my lord, they are frequently raiding my house and my lord, asking for my presence in the police station. But my lord, there are no record and nothing has been given that in what case or for the what reason, my lord, they are frequently visiting my residence, my lord. Now, my lord, as apprehending that as this is an issue regarding the marriages of the child marriages, my lord, and due to the policy of the state, as some of the Kazis or the Muslim marriage registered in the other part of the state, my lord, has already been arrested and some has obtained bail also. But my lord, as I have not found any case against me, my lord, so therefore I am now before my lordships, my lord, for consideration of the issue, my lord, that whether my act under the 1935 is a valid one or not, my lord. Now, for a moment, my lord, I beg to draw my lordship's kind attention to the act of 1935, my lord.
Yes.
My lord may be pleased to find the provisions of the act, my lord, starts at page number, my lord.
Yes, we have it.
Yes, my lord, page 63 of this manual, my lord. No, my lord, the act starts at page
50.
Yes, my lord, page 50, my lord. My lord, can skip the few part, my lord. Interpretation, Muslim register definition is given, my lord, in section 2, subsection 2, means any person who is duly authorized under this act to register the Muslim marriages and divorce. Now, my lord, section 3 says at page 52, my lord.
Section 3 license.
Yes, my lord. The state government may grant license to register, my lord. The state government may grant license to any person being a Muslim, authorizing him to register Muslim marriages and divorces which have been effected within certain specified limits on application being made for such registration and may revoke or suspend such license also, my lord. Now, my lord, the applications, this is important, my lord, at section 8 at page 53, my lord. Applications by whom to be made. Every application for the registration under this act shall be made to the Muslim registrar orally as follows. If the my lord, may kindly note that, my lord, application is not even required to made by, my lord, in a written form, my lord, they can go for oral request also, my lord. If the application for the registration of a marriage by the parties to the marriage jointly provided that if the bridegroom or the bride or both be minors, application shall be made on their behalf by their respective lawful guardians. Just pausing for a moment here, my lord, my respectful submission, my lord, in regarding this, that the state of Assam, my lord, they have recognized that the minor Muslim marriages is happening, my lord. And therefore, my lord, as a result, my lord, what they have done under this statute, my lord, by considering and giving the, my lord, authenticity to the Sharia Application Act of 1937, my lord, they have recognized that the minor Muslim marriage is also governed under the Sharia Application Act of 1937. That's why, my lord, in this specifically said that if the marriage is between the minors, my lord, then the applications can be made by the lawful guardian. So, my lord, if such application is made by the lawful guardians and provided further, then I am authorized to, my lord, register the marriages of such minors also, my lord. That is my limited understanding, my lord. And secondly, my lord, duties of the Muslim registrar on application. Now, how he is required to, my lord, register is also assigned here. On applications being made to a Muslim registrar for registration under this act of a marriage or divorce within 1 month of marriage or divorce being effected and not otherwise, and on payment to him of a fee prescribed as per the schedule 4 to this act, the Muslim registrar shall. Now, my lord, here come clause as satisfy himself whether or not such marriage or divorce was effected. Now, my lord, before registration, he is required to satisfy himself that whether the religious rituals or the marriage was solemnized or not. Now, if the marriage, the religious ritual is not solemnized, my lord, or if the, my lord, there was no religious rituals was affected before the such application is made, my lord, then as a Muslim marriage register, he can refuse registration of the such marriages also, my lord. Satisfy himself as to the identity of the person appearing before him and alleging that the marriage or divorce has been effected. In the case of any person appearing as a representative of the man or the woman, whether he appears as a guardian or wakil, satisfy himself of the right of such person to appear. Now, my lord, if we go by the entire provisions, there is nothing, my lord, stated herein that the age is also required to, sorry, my lord, age is also required to be examined, my lord. That is not here. So therefore, my lord, my respectful submission, my lord, is that under the provision of the section 8 and 9, my lord, as a Muslim marriage registrar, my lord, I even can go for the registration of the minors Muslim marriages, my lord, after the due verification and satisfaction, my lord. Now, if we go by the provisions of the various provisions, my lord, my lord may skip these provisions of this statute, and the rule 26 is also relevant, and which my lord may be pleased to find at page 73, my lord.
20?
My lord, I am referring to the Assam Muslim Marriages and Divorce Registration Rules of 1935.
Section?
My lord, Rule 26 at page 73, my lord. In this manual, my lord.
Rule 23.
My lord, Rule 26, my lord.
20. Procedure.
My lord, the procedure before registration, that is, my lord, relevant. That's why I'm referring, my lord. The Muslim registrar shall satisfy himself whether or not a marriage was effected by the person by whom it is represented to have been effected in the following manner: by examining the parties to the marriage, or if either or both of them are minor, their lawful guardians, and if the woman be pardanasin, our duly authorized wakil shall be examined instead of the woman, by examining the two witnesses who were present at the marriage. So, my lord, this is very clear that the solemnization part is, my lord, is required to be over before, my lord, this procedure of registration is going to be affected by such Muslim marriage register. So, my lord, therefore,
You have referred to which rule?
My lord, Rule 26, my lord has got this book, my lord, at page 73, my lord.
26.
Rule 26.
Procedure before registration.
Yes, my lord. Procedure before registration.
Yes, what did you submit?
My lord, the Muslim registrar shall satisfy himself whether or not a marriage was effected by the person by whom it is represented to have been effected in the following manner. Number one, by examining the parties to the marriage, or if either or both of them are minor, their lawful guardians, and if the woman be a Pardhanashin, her duly authorized vakil shall be examined instead of the woman. Number two, by examining the two witnesses who were present at the marriage. My lordship is well aware, my lord, when the Muslim marriage is solemnized, my lord, the proposal is from the my lord bridegroom to the bride, my lord, goes in presence of two witnesses, my lord. If the proposal is accepted, then my lord, if Kabul is given by the bridegroom, by the bride, my lord, then it will again come back to the my lord bridegroom, and if the acceptance is on the both sides, then the marriage part is over. For the said purpose, my lord, two witnesses is very, my lord, vital. So therefore, this, my lord, Muslim marriage registrar is also required to examine the two witnesses who accompanied the proposal and acceptance part, my lord. So therefore, my lord, from this reading of Rule 26, my lord, my respectful submission before my lordship is that, my lord, the solemnization part is required to be over. Then the role of this Muslim marriage registrar will come. Then he can register, my lord. My lord, on the other hand, my lord, the registration as a Muslim marriage registrar, my lord, I have to also maintain the records that how many, my lord, marriage has been solemnized or registered. And that record is also required to be, my lord, required to be submitted before the concerned authority, my lord, and which my lordship may be pleased to find. Lord, it is in the act, my lord, in the act. My lord, this is at section 16 at page 56, my lord. Muslim registrar to be the subject to the control of the district registrars, my lord. At page 56, I am referring, my lord. Every Muslim registrar shall perform the duties of his office under the superintendence and the control of the registrar in whose district the office of the such Muslim registrar is situated. Every registrar shall have authority to issue, whether on complaint or otherwise, any order consistent with this act, which he consider necessary in respect of any act or omission of any Muslim registrar subordinate to him. Power of the state government. Now, my lord, may again come to registrar at page 57, my lord. Section 18. The Inspector General of Registration shall exercise a general superintendence over the office of the Muslim registrar and shall have power to frame regulation from time to time consistent with the rules made under this act for the guidance of the said Muslim registrar and their offices generally. Now, my lord, here I am pausing for a moment, my lord. As the child marriage, my lord, is a prohibition under the Child Marriage Prohibition Act, my lord. If the government is so conscious in case of the Muslim marriage register, then in compliance with section 18, my lord, they could have framed a guideline, my lord, authorizing or my lord guiding us that you do not register the Muslim marriages of the minors, my lord. Till date, in exercise of the section 18, no any guideline, my lord, had been issued by the Inspector of General Registration as per my knowledge or as per the instruction which I have received, my lord. So therefore, the government is conscious and allowing us to, my lord, to register the marriages of the Muslim minors, my lord. My lord, and section 21 also says, my lord, that the every Muslim registrar shall at the expiration of the every month send certified copies of all entries.
You did not emphasize on those
My lord.
ancillary factors.
My lord, my lord.
Your main contention is that if you come to the Act of 1935,
My lord.
8(1),
Yes,
which itself provides for a
minors.
situation where minors can also be the parties.
Yes, ma'am. Yes, ma'am.
And if the Act itself gives such a provision, then
Right.
the question of the act being an illegal act will not come.
Not
Number
come.
one. Number two, you say that you do not affect the marriage. You only register an affected
Exactly.
marriage.
Exactly, my lord.
And you only need to be satisfied that the marriage has already been affected.
Affected, solemn.
Whether it is a superintendence or not, those are the ancillary matters.
My lord.
You are covered by the 1935
My
Act.
lord. My
You are not performing a marriage, you are only registering a marriage
Yes.
which has already been affected.
Exactly.
And that marriage which is affected can also be between minors, as per
Yes.
section 8.
Yes, that is my,
your
that is
case.
that.
So there is no penal offense as such.
Yes, yes, my
There is
lord.
no situation or
Exactly.
occasion to harass you or to, that's your case.
That
You
is my
understood your
case.
case.
That is my case.
Anything,
My lord.
Mr. Mazumdar? Will be only on the point of law, Mr. Mazumdar.
Absolutely. I'll be referring to only the provisions of the law only.
Please.
Before that, your lordship will permit me to point out certain things from the facts, just limited things which are necessary. Refer to the provision. Lordship may kindly see page 67 for a moment of the report. 7, the notice apparently against which the writ has been filed. 67 is a letter, my lord, issued by the Inspector General of Registration, Assam, whereby this letter, my lord, with reference to the subject cited above, I am directed to enforce herewith the license issued by the government in favor of you to act as MMA and Kazi. There are two things. One is Muslim marriage registrar and also as Kazi. Within the jurisdiction of Nilam Bazar Police Station in the district of Karimganj.
Just a minute.
There is a Kazi's Act of 1880, man.
You are just referring to the license.
Yes, I'm sorry, my lord, it's actually license. Page 67 is the license. I'm showing this letter, my lord, point out that he is in good license to act not only as a Muslim marriage registrar, but also as a Kazi.
We are trying to locate the headings at page 27.
That is what, next I'll take your lordship. I'll take your lordship to.
He gets jurisdiction and powers from two acts.
Yes.
One is the 35 Act and one is the Act of 1880.
1880. I'll come to that a little later, manner. Now,
Mr. You're not required to fill up your pleadings with the provisions of the Act and rules.
Hello?
Those are available. The first page till page 27 are all provisions of your quotation from the law. What is the requirement? You have to, there should be pleadings in your case.
Lord,
You don't even say who are you in from the first page. First time you say page after in page 27.
my lord,
That's not requirement.
my lord. Yes, my lord, actually what
You
is
can
meant-
save your energy, your paper.
my lord.
These are available.
Actually, my lord, it is escaped. What has happened, my lord, some hurriedly it has been dropped.
No, hurriedly you are taking more time.
My lord.
27 pages of the act and rules. Direct
No, my
quotation.
lord, we have also, my lord, stated regarding the marriage of the Muslim marriages, the different pronouncement in the Quranic.
No,
verses.
we are not, you can say whatever you want to say in your pleadings. These are not pleadings. These are
Yes,
extracts of the law.
My lord,
Okay,
that is
yes,
correct.
My lord, page, my lord,
But
lordship has seen-
we have just realized that this act which is referring 1935,
Yes, yes.
that is the registrar. Otherwise, the 1880 makes him the Kazi also.
My lord,
My
He is also the Kazi. You are trying to highlight on that.
yes,
And this notice was given to him as MMR as well as Kazi.
my lord. Lordship may kindly, lordship has seen as page 67, he is to act as MMR as well as Kazi. Now, lordship may kindly see the complaint which, and the notice which has been issued. Page 69, my lord.
67 is the notice. Page 69.
This is the impugned letter issued by the executive.
And
magistrate.
Kazi
Yes, my lord, executive magistrate, but then from the office of the deputy commissioner, there is a reason, my lord,
and Kazi.
but it was issued from the office of the deputy commissioner, my lord.
Yes.
Now, lordship may kindly see just 3 paragraphs, small paragraph. Whereas certain complaints have been received that you have been registering marriages violating the provisions of the
You
prohibition.
see the description?
My lord,
You see, read his description also
description of what?
of the petitioner.
Yes. And Kazi, yes. And notice has been issued to him, my lord, because he has acted not only as an MMR but also as a Kazi. Now, the first paragraph says, whereas certain complaints have been received that you have been registering marriages violating the provisions of the Prohibition of Child Marriages Act 2006. Whereas there are prima facie evidences and documents produced before the undersigned and early child marriages were registered by you, which attracts penal action for non-compliance of the provisions of the aforesaid Act. You are therefore asked to appear at the office chamber of the undersigned along with all records, registers, etc. pertaining to the marriages registered by you during the years to 2021 and 2020. The specific particulars and records of registration in respect to the following cases on 4/3/2023 at 11 AM without fail. Now he has given the names also. Timothy Suenso, I'm not deliberately now naming them, my lord.
Yes.
Uttering their name. So 4 marriages were registered who were all minors. Now this is the allegation. Now, lordship may kindly turn to para 13 of the writ petition at page 30. My lord. In fact, your lordship kindly permit me to read just the paragraph from page 29. I'm sorry, my lord.
Page 29.
My lord. Para 9. Page 29, lordship has got, my lord.
Yes.
That although the aforesaid Child Marriage Prohibition Act been enacted in the year 2007, but the government, more particularly the state government, was in a deep slumber and did not restrain the child marriage in letter and spirit. But it is only on 23rd of January 2023 the state cabinet accorded its approval for the purpose of initiating a massive drive to crack down on those involved with child marriages, and the state home department was asked to initiate crackdown drive against those persons found committing of offences under the provisions of Child Marriage Prohibition Act 2006, as stated therein above. Accordingly, the State Home and Political Department acted upon the nod of the state cabinet and registered more than 4,000 cases all over the state in various places, police stations, and also arrested more than 4,000 accused involved in child marriages. Complaints to FIR had also been lodged against the present petitioner. Also, kindly note, there is an FIR against him, alleging registration of child marriages before the DC, Karimganj. In the said complaint, though not made available to the petitioner, but he has reliably learned that bogus and vague complaint had been lodged against the petitioner for registering child marriages while discharging his public duty as MMR. That the office of the DC on receipt of the aforesaid complaint issued a notice which is so-and-so addressed to the petitioner whereby and whereunder it had been categorically stated that the said office had received certain complaints against the petitioner that he had been registering marriages by violating the provisions of the Prohibition of Child Marriage Act 2006. The office find from the prima facie evidence and documents produced before the office of the DC Karimganj, which stated that some attract penal action against the petitioner. Therefore, it was directed to the petitioner to appear in the office chamber of the signatory of the notice along with all records registered pertaining to the marriage register petitioner by the petitioner during the year 2021 and 2022, specifically with the record of registration in respect of registration of the person concerned mentioned in the notice itself. Next paragraph, my lord. That the petitioner on receipt of the aforesaid notice, being a law-abiding citizen, appeared before the office of the executive magistrate Karimganj, along with all available records as regards the registration of marriages carried out by him in the capacity of Muslim marriage register Nilambajar in the district of Karimganj, Assam. During the course of hearing of the petitioner, he produced all relevant records including the specific register as well as other records pertaining to the registration of marriages of the persons involved in the notice itself. But this is important. During the course of the aforesaid hearing, the concerned executive magistrate expressed her dissatisfaction over the registration of Muslim marriages alleging to be minors, and therefore the said executive magistrate intimated the petitioner verbally initiation of criminal proceeding against him for the alleged offences of violations of the provisions of Child Marriage Prohibition Act 2006, and further restrain the petitioner from registering such alleged minor marriages in near future. Now, this is important, my lord. Immediately after the date of hearing, some police personnel from Nilambajar police station visited the residence of the petitioner on 5/3/2023 at around 1 PM for the purpose of investigating arrest of the petitioner. But as on that day, as the petitioner was absent from his home for certain official works, therefore the petitioner could not be apprehended by the police of Nilambajar police station on that day, that fateful day. Therefore, the police of Nilambajar police station asked the family members of the petitioner to make the petitioner available before the police immediately. As such, the petitioner is now apprehending his arrest by the police of Nilambajar police for the registration of the alleged child marriages. I'll just pause for a moment here. If the ultimate intention of the petitioner is to get rid of those criminal cases registered against him, number one, and to protect him from arrest, he should specifically come forward saying that these are the cases registered against him. He knows that he has been told that there are criminal cases, FIR and complaint. Now he could have, I mean, there are ways to obtain the copies of those FIR and the complaints. Those have not been disclosed before your lordship, my lord. They have been deliberately suppressed before your lordship by the requisition. Neither are the copies of the complaints in FIR nor any statement as to under what provision of law. I'll just indicate to your lordship that under this act, this child marriage is a criminal offence. Under the POCSO, it is a criminal offence. Child has been defined in both the acts. Now, POCSO, there is a provision, my lord. Before I take your lordship. In the POCSO, there is a provision, my lord, section. Section 42A. Lordship, if the lordship is holding this book, my lord.
POCSO?
My lord, this green.
No, we have a different, doesn't matter. We have 42A.
42A, lordship, may kindly say. I'll read two more paragraphs from the report, my lord. Before that, I'm just showing it.
Act not in derogation.
My lord, act not in derogation of any other law. The provisions of this act shall be in addition to and not in derogation of the provisions of any other law for the time being in force. And in case of any inconsistency, the provisions of this act shall have overriding effect on the provisions of any such law to the extent of the inconsistency. Now, that being the position, my lord, even under the Shariat, my lord, even under any other law, if the child marriage is permitted under the Mohammedan law of a minor, after this act has come into force, unless this provision itself, section 42A is challenged, virus of section 42A, then any case complaint registered, FIR registered, has to be subjected to provision of that law, unless he challenges the validity of this section and this act itself.
It has an overriding effect.
Overriding effect. Let us assume for a moment that child marriage is permitted under any other personal law of any person. Any person marriage under any religion. Now I will kindly permit me to read two more paragraphs from the repetition. Just two more paragraphs.
Just a minute, just a minute.
Because, my lord, I'll take your lordship to the provisions of the Kazi's Act of 1880. There, my lord.
Just a minute. So this POXO has come into effect from
2012, my lord.
2012, 28th of June.
My lord.
So this is prospective effect.
Yes.
Are these the four instances? Are those instances post 2012?
Yes, my lord. We have done. Yes.
Yes. Registration is after 2012. That is correct.
My lord, if
No, but did he act as a Kazi?
well, that is what I'm showing, my lord. Lordship will kindly see now. But lordship, just permit me to read one more paragraph from this petition, then I'll take your lordship to provision of the Kazi's Act, my lord.
No, there will be two eventualities.
My lord.
The act which he has done while discharging his duties as a Kazi,
My lord.
and the act of registering as an MMR.
My lord.
Those are separate acts
Separate.
under two separate statute.
Yes.
One is the 1860, one is 1935.
Yes.
Now, 1860 may be inconsistent with POXO. POXO will have an overriding effect. But that too after June 2012.
My lord.
And act of a Kazi by some other Kazi, he registers after 2012
My lord.
by under the act of 1935.
Yes.
His act is only of registration.
I'll
His
come
act
to
is
that.
not his.
My lord, here is a case where although the petitioner is saying that I'm only registering, marriage has already taken place.
Correct.
No. If he acts as a Kazi,
That is it.
then,
Whether he had acted as a Kazi or not.
my lord, for all those will be a part of the investigation. This on the court will not do the investigation.
No, was his act restricted only for registering these four cases? Or did he also affected the marriage as a Kazi?
My lord, if he acts as a Kazi, we do not know, my lord, today, because these materials are not placed before your lordship. If he acts as a Kazi, will it not be amounting, abating the marriage? Because he will be there and he is required to be there. My lord, lordship.
As a Kazi?
My lord.
Kazi, yes, it may be an offense under
Yes.
the POXO Act,
Yes.
post 2012.
Yes, man.
But as an MMR,
As an MMR also, you are registering a marriage which is not permissible under the law. Now by registering, you are giving authenticity to the marriage. Is it a part of abatement, my lord?
no. See, registration is not essential.
No, not essential. But if you register, then what will happen? Registration is not essential. But if you register by being present during the marriage, solemnization of marriage,
Yeah, the solemnizing a marriage, effecting a marriage is one thing, and registering a marriage which has already been done is another thing. He does it under a
And
law.
all these things, your lordship is absolutely correct. If it is found that at the time of solemnization of marriage, he had no role to play, subsequently, maybe after 2 years, maybe after 3 years, somebody came and registered the matter, maybe slightly, I'm not sure, my lord, matter may be slightly different. But today we are at a stage when only the proceeding has been initiated by asking him to produce the records. And side by side, he
But
himself.
you admit that on a particular date, of course, the law from the date of its promulgation, it takes effect.
My lord.
But here, from 2012 till such and such date, it was not strictly followed. One day you announced that it will be done. Can actions which were done before that, can it be an offense?
My lord, whose materials are not before your lordship, whether he has been asked to produce documents in respect of actions which were prior to 2012, we do not know, my lord. He has been asked to produce only the records of particular 4 marriages. Now, in connection with those 4 marriages, if we find, if the authority investigating is
No, he has already, he said that he has already produced the records, documents of the 4
but they were
marriages.
not satisfied. That is why they are before, he is before your lordship. It is his statement. That is why I have read those statements, my lord.
So what is your instructions on on that aspect regarding the reasons of being dissatisfied or not being satisfied?
My lord, I have not have any instruction, my lord, from the authority, but my submission before lordship will be when the petitioner himself is saying that authority was not satisfied and authority thereafter.
So was there any written communication made to you?
No, my lord.
How did you know that they were not
Not on the
satisfied?
day when I appear, my lord, on the production, they have asked me not to go for any future registration of the minor marriages, and we are also going to initiate criminal
Lordship
proceedings.
may have a written
My lord, may 10 instruction also. Record के लिए है।
Says, my lord, he has admitted about marriage.
Is there any statement of solemnization or affecting the marriage?
My lord, I do not know. If he.
Your focus is mainly on the registration part as an MMR.
My lord, if the registration is followed by a marriage where he was there as a. my lord,
No,
Kazi also.
registration is not followed by marriage. Marriage is followed by registration.
No, my lord. First, my lord, supposing a marriage takes place. And he's a part of the marriage as a Kazi.
That's it. No, that part we are not finding it.
That instruction we can bring, my lord, specifically from them. But
No,
then,
there are some. There are some materials, including his statement, your inquiry. Your focus is on the registration part. That he has signed the filled forms. On the solemnization or affecting part, there is no statement.
my lord, even the registration in my humble service amount to abetting the.
That we'll have to examine.
Well, I'll find out. The lordship may give a couple of days. I'll find out from the.
You find it out.
Whether he participated
If
as a Kazi also.
if his duty is only for being a registrar
I know.
under 35, then our views may be slightly different. But as a Kazi, our views may be different.
My lord, there is a. Only possibly solemnization is also there.
Formalization, who's his statement?
My lord.
What is the statement? Can you read it out, madam?
And solemnize on marriage form as the verification.
That is not meaning a solemnization. That is the registration part.
As I was unaware of the.
No, there may be still an instance of he acting as Kazi. But that line is not clear.
I married and because of my.
Yes.
Let me find out, madam, specifically whether he.
No, he has admitted. He says that he's saved
He
by
has done, yes.
the 1935 Act.
My lord.
And we may still examine is his argument that it may still amount to abetting.
And what I am trying actually to submit, that under, if he has only registered under the 1935 Act, and whether that act on his part will amount to offense under the POCSO or under the 2006 Act.
No, you are right that POCSO has got a non-obstance clause, though the expression notwithstanding is not there, but it's clear that it has got an overriding effect. And then it's also settled law that the law under list 1 that will prevail. But this law is also not repealed.
Yes.
Now, in such a case, would it be reasonable to punish him, have a penalty?
Similar matter, more or less similar matter came up before.
Because the consequence is penalty, penal offense, imprisonment. Yesterday, the smoking in public was not an offense. Today, smoking in public is an offense. Can you hold him to be guilty of an offense done 10 years back?
And Lord, may kindly look at this statement. Kerala High Court, my lord, very recent, decided on 18th of November 2022, my lord. There, my lord, Lord, will kindly see from section 10 onwards. Muslim personal law Sharia application in 1937 stated recognizes, there are 10, my lord, that in all questions relating to marriage, the rule of decision shall be the Muslim personal law Sharia. However, after coming into force of the Prohibition of Child Marriage Act 2006, it is questionable whether the said personal law will prevail over the special statutes relating to marriages under section 3 of the said Act. A child marriage shall be voidable at the option of the contracting party with the child, but section 12 makes a child marriage void in certain circumstances. For the purposes of easier comprehension, section 12 is extracted as below. Then Lord Shima kindly say para 12. In the instant case, since the investigating officer alleges that the victim was enticed by the accused without the knowledge of her parents at the age of the victim being only just above 14 years at the time of alleged marriage.
You come to paragraph 22 and 23. 23.
Yes.
The girl was abducted from West Bengal, taken to Kerala.
Yes.
Facts are entirely different.
No, my lord, that law has been decided.
No, law is decided on the facts, on certain facts.
Para 17 says.
Here, parents are there with the child.
My lord, para 17 says, in accomplishment of the intent, the POCSO Act has defined the word child in section 2 as any person below the age of 18 years. To put at rest any doubts over the applicability of the Act, section 42A has also been incorporated, which is as below, which we have read, my lord. The aforesaid section categorically asserts that in the event of any inconsistency with provisions of any other law, the POCSO Act will prevail. Personal laws and customary laws are both laws. Section 42A intends to override such laws also. Therefore, it can be gainsaid that after the coming to force of the POCSO Act, so with a child, even if it's under the guise of marriage, is an offense. Then section para 19, which you kindly see in the decision so I am unable to agree to the proposition later in the decision. Then, my lord, para 22. In view of the above discussion, I am to consider view that marriage between Muslims under the personal law is not excluded from the sweep of POCSO Act. Para 22. If one of the parties to the marriage is a minor, irrespective of the validity or otherwise of the marriage.
Oh, see, you have yourself read paragraph 19.
My lord,
And fairly pointed out there are decisions on this side also,
my lord,
that criminal proceedings were quashed.
my lord.
This is a view of the Kerala High Court,
Kerala.
single
My lord,
judge.
my lord, what I'm saying today is, now, whether it will be an offense or not, whether by registration there will be a question of abatement or not, all this will be decided by the investigating agency, whether they ultimately accuse him or not. If this on the court takes up that exercise, my lord, so far as the validity of marriage is concerned, another thing. Now, in view of the specific provisions of the POXO Act, particularly 40A, and also the provisions of the marriage, Prohibition of Marriage Act 2006, when it's a criminal offense, whether those acts on the part of the Kazi being present and solemnizing the marriage will be, and also the registration will be an abatement of offense or not, that will be decided by the investigating.
See, we are making a balance between a criminal offense or an offense under a penal offense, where the consequences are very serious. And here is something which is permitted by a law, which is yet to be repealed.
Yes.
Now, under those balancing,
What I'm saying is, Lordship,
for acts done prior to the drive taken by the government without any announcement, will it be proper to punish?
my lord, I'm not saying that be punished. What I'm saying is, my lord, by this repetition in the guise of repetition, he is actually avoiding the criminal consequences. Let him face that, let him satisfy that no case is made out, and maybe the charge sheet will not be submitted.
He is before us with the issues. This may not be a case of preempting or circumventing. He is raising a legal issue. In a given case, we may say that no, not proper, not even mature.
Now that here, my lord, here that
He is the
he acts as a Kazi also. Now,
That's a different thing.
my lord,
If tomorrow you come up with instructions that as a Kazi also has discharged duties,
my lord.
but then we have to see the 1880 Act. What kind of, is there any kind of
solemnization there?
no, solemnization is definitely there. What is the duty the one a Kazi is entitled?
He's
Come to 1860,
my lord, yes, 1880, my lord.
1880.
My lord, Lordship, may kindly see the object of the act, my lord. Statement of objects and reasons. I'll not trouble your Lordship with all this, my lord. Just page 28 of this book, your Lordship is holding this book, my lord.
Yes.
Page 28.
Yes, we have this.
Then, my lord, I can skip the first part. This from this paragraph, my lord, the line about 4th or 5th from bottom. The presence, writing segment after
Yes,
the
yes.
word India, my lord, within brackets. The presence of Kazis appointed by the government is required at the celebration of marriages and the performance of certain other rites and ceremonies. And it is therefore expedient that the government should again be empowered to appoint persons to the office of Kazi. So a Kazi is there to not only solemnize marriage, but also to see that certain other rites connected with the marriage is performed.
No, is the duty of a Kazi to solemnize marriage?
But his presence is required because
No, does he solemnize the marriage?
my lord, Dr. kindly see says his presence is required.
No, come to the object, his duties in the statement of objection reasons.
My lord.
Duty perhaps is not to solemnize a marriage. Preparing and attesting deeds of transfer and other law papers, celebrating marriages and celebrating and presiding at divorce.
Yes.
He is not to be presiding at a marriage. He has to celebrate. He has to be present.
My lord, he says
Performing various rites and ceremonies.
yes, part of the marriage. The parts of the marriage. A person remains there and he takes part.
Superintending the sale of displayed properties and paying charitable and other pensions and allowance.
Well, these are actions, these are acts on the part of the Kazi, which is a part of the marriage. To accord solemnity to the marriage.
Solemnizing. Affecting.
His presence is essential, it says, in this subsequent next page paragraph. Certain of his duties having thus survived by passing of Act 11 of 1864, that Kazi is still functionary of considerable importance in the Mohammedan community. What was originally in some sense an accidental adjunct of his judicial office has become his principal and only duty, and in some parts of the country, at least the presence of a Kazi at certain rites and ceremonies appears now to be considered by Mohammedans essential from their point of view. He is supporting this. It is not abatement, my lord. We are not deciding as to whether charge sheet be issued or not, but it is for the investigating agency to consider all these things. They're all matters of facts to be taken into consideration by the investigating officer. And as
See the last line, last line, to prevent any possible misapprehension.
This point, a saving clause has been added to the effect that nothing in the bill confers any judicial or other powers on the Kazi
or makes his presence necessary
at any marriage or other ceremony, at which presence is not now.
See,
No, my lord.
the law doesn't say that his presence is necessary for a Muslim marriage.
What I'm saying is, if he remains present, what is important law is another thing. If he remains present as a Kazi and he says that I'm
You get the instructions regarding the Kazi part.
after tomorrow, my lord,
Is it possible?
then after the
After the vacations, immediately whenever you say, Third Sri AR here, Learned Counsel for the petitioner. The state is represented by Sri D. Mazumdar, the Learned Additional Advocate General, assisted by MS S. Sharma, Learned Government Advocate. The State Council has raised an issue on the duties discharged by the petitioner, both as a Muslim marriage registrar and Kazi, and points out that the notice issued to him was in both capacities. Full stop. He submits that though the Muslim Marriage and Divorce Registration Act of 1935 contemplates a situation where registration is done by the registrar after a marriage has been solemnized, as a Kazi, the marriage itself is solemnized by such a Kazi, full stop. The Sri Mazumdar, however, submits that submits that no instructions are immediately available on the role played by the petitioner as Kazi, for which he prays for some time, full stop. That the matter will be listed immediately after the, you have a date?
26th.
On 26th of
April.
Okay.
I'm making one submission subject to lordship consent. Even by registering also, my lord, of a minor.
We'll hear that.
Is an offense.
We'll hear that.
And that's my submission.
After submission first, it is submitted by Sri Mazumdar, the Senior Counsel for the state, that there being an overriding provision in the form of Section 42A of the POXO Act, even registration by a registrar by the petitioner as MMR would amount to abating an offense and would be punishable.
If the parties to marriage child.
Lord, interim.
Punishment would be abating an offense, and that aspect is required to be taken into consideration.
My lord, interim protection may kindly be continued.
Is there any interim order?
No.
Interim order passed earlier to continue till the next date of listing.
Obliged.
Okay.
Please, your lordship. In this matter, the certain tender conditions were challenged.
Yes.
Being not, my lord, relevant for the purpose of to be achieved.
Malt.
Yes, my
Yes.
your lordship directed them to produce the.
Yes.
My lord, your lordship was directed to tenders recover in the last one.
Hmm.
I've received that.
You have received it. What is it?
The tender document of all the parties. That was directed.
Financial bid is also there.
Yes. Whatever is there, my lord, in the seal cover, I have not opened.
Has it been revealed to you? No.
No.
You have not seen those?
No.
We'll do one thing, we'll have it tomorrow. We'll have this examined and have it tomorrow. Instead of taking time now, after the court rises, we'll have a look at this. We'll take the assistance of the registry. In terms of the order dated 27/3/2023, 3 D.K. Sharma, learned additional senior bar advocate Assam, has produced the records, the bids of the respective parties in seal cover. Full stop. Since some time will be consumed to examine the same comma, that the matter be listed again tomorrow for consideration.
There are 4 participants, my lord, all the documents are there.
4 bidders.
4 bidders.
Can I be the after tomorrow? Or I may have some difficulty.
After tomorrow. If very register tomorrow. Since time will be coming, matter since some time would be consumed. Consumed, let the matter be taken up on any other date. Full stop. As requested, list on.
Yes, tomorrow is 12.
12. As requested, list on day after tomorrow. 12. This day after tomorrow. 12. Yes. Same, I think.
Same law, sir.
Yeah, only thing is that your lordship will see, I have already filed the return under section 39. That is, that's paid.
Now everything will be reconsidered.
Your
Don't
lordship,
worry.
since I have also filed the return as required under section 37. So already I am here before your lordship. Only thing is that now again, if I have to approach, it will be time consuming. So during the 5th January itself, I have filed. I can place your lordship.
That can be considered, I think.
Lordship, as per the circular, only on doing the necessary formalities with regard to the filing of returns, other penalties and taxes, then only the revocation will be done. Lordship, since he has done, that will be taken into account by the authorities when he makes an application.
You can make an application, formal application that you have already given, that will be considered.
That may be ordered.
Yes, because the circular itself.
That will clarify. That will clarify. Was it ordered? Is it ordered?
In item 23, Lordship.
Hello? What's can you pull the deal, huh? Better number?
23, Lordship.
This is 26. 20.
It's a B. Ushilal. Arote. P. Chaudhary. So that is here you can require. Registration number to board businessman. Businessman as a service provider with the Department of Post. Full stop. Registration number to your Pasailapa. Failed to submit his returns with a conference. Show cause notice date to board people. You are not a tax savvy person.
No, yes, lordship.
Or just for the sake of it, you have written. Otherwise, you use gazettes, WhatsApp. Don't use WhatsApp.
Your lordship, but not up to date.
Not updated. Okay. Cancellation. cancelled his registration with effect from order dated 8267. As Petitioner submits that in the meantime, he had, what did you do?
On 5th January 2023, this STL one that is under section 37 was already filed.
He had filed the returns on 5th January 2023. Under section 37.
Section 37.
Which is yet to be considered.
After that, we filed an appeal that was not considered. Due to the limitation, appeal will not be taken up.
37, which was followed by filing of an appeal, which was also rejected by an order dated 31/1/2023 on the ground of limitation.
In fact, there was a ground mentioned, Your Lordship, that was also not considered.
Yes. This was the. Okay, take it. Sir. Okay.
Obliged. Banco Boraj.
In the RFA, who's there? You are also there in the RFA?
No, I'm not there.
You were there earlier.
No, I was in item number 1, that is related to this matter.
Your name is also shown in the RFA? Mr. P.K. Kalita, his colleague. There are other councils also. Then
Yes, Lord.
in the connected RFA, Mr. Borbia, P.R. Mohanto Asar Gogoi. Hello. The M.K. Bora, Learned Counsel for the petitioner has submitted that the brief has been taken back by the clients and he is no longer appearing. Full stop. No other counsel has appeared today. Full stop. Para. In the interest of justice, matter stands adjourned to be listed again on 21st of April.
Obliged.
Places, Your Lordship. Item 51 and 52 can be passed over for timing, Your Lordship.
Time being.
Yes. Seniors and lakes.
Is it state or central?
State, Your Lordship.
Who's the state finance?
Finance is the party here.
Try to have him in the court, maybe taxation department.
Yes, Your Lordship.
Okay, we'll have after some time.
Okay.
This is a solicited case, Lordship. Already 7.
Scan copy is in.
Scan copy has received, Lordship. Petitioner is done.
Where is he?
Done.
None appears for the petitioner on call. However, PS plus Locker, Learned Counsel, Learned additional PP is present. The in terms of the earlier order, it is 22/3/2023. The scanned copy of the case records have also been transmitted to this court para in the interest of justice. Please, Dr. Ravi.
Yes, sir. Simple.
Yes, yes.
This matter, this petition has been filed against the order passed by the Termination Board of Revenue. The lordship will find input order at page 34. The matter relating to my lord, correction of records.
You are for SP number 4. You are for SP number 4, madam?
Yes, lordship.
My lord, in this case, I am for Revenue Department. We need a copy of the repetition. They may be asked to furnish it.
Mr. Nathi needs a copy of the,
We have already submitted long ago, my lord. Yes, sir.
give a copy to him. We'll have it immediately after the vacation.
Yes, ma'am.
Sri Bhattacharya, Learned Standing Counsel, Revenue Department submits that he is not equipped with the copy of the writ petition. Full stop. Sri Nath, Learned Counsel for the petitioner, has undertaken to serve an extra copy to him by tomorrow.
Tomorrow.
List out immediately after the, it is 17 matter. We'll fix a date, a list on 19th of April.
19, yes.
Why, what is your name, Mr. Nath?
Yeah.
Your name, petitioner's name?
Your name is my lord. It is very interesting, my lord. Laddu Namaskar.
Laddu.
Namaskar, Laddu.
You're fond of Laddu, your shape is a Laddu.
What the Laddu?
Fond of Laddu. Or maybe your shape is like a Laddu.
Yes, ma'am.
Sir Sharma?
Not complied, lordship, till date.
Not complied. Yes, who's appearing?
He also, Mr. Gogoi appearing for chief engineer, he is also not appearing in the court when case is listed. So,
P. Gogoi Nayak. Has somebody appeared for the newly implemented respondent?
lordship, Mr. B. Gogoi, respond number 5, lordship.
Mr. Gogoi, where is he? Contempt matter. Ask him to come. He says it's not be, he's yet to be complied with. Ask him to come.
Yes, sir. May I pass over to Lordship, in this matter, I've just now I've received the affidavit in opposition, Your Lordship.
Opposition?
Affidavit in opposition, signed copies of the affidavit. Your
Oh,
Lordship.
you need to fight it.
Yes, just now I've received, Your Lordship.
Okay.
Kindly fix it any day, Your Lordship.
MSN Board Learned Standing Counsel, Revenue Department submits that the affidavit in opposition is ready and it will be filed during the course of the day.
Yes, sir.
Full stop. You'd like to file a rejoinder?
That we'll have to see the affidavit one.
That the matter will be listed after 2 weeks to enable the petitioner to have instructions, to enable the learned counsel for the petitioner to have instructions as to whether any rejoinder is required to be filed.
I'm deeply obliged.
Let the affidavit in opposition be tagged with the records.
Much obliged. May I please the lordship, as order of the last occasion by the Honorable Court, notice has been served, my lord. My lord. It is clear for compulsion.
No, as per number 6, did you take fresh steps? Okay. Okay.
My lord, as per order dated 17/3/2021. My lord,
Yes, what is your instruction, madam?
Your lordship, we have to file affidavit, your lordship.
File the affidavit.
Yes, your lordship.
As per office note dated 12/9/2022, comma. Service note, service on the respond number 6 is deemed to be complete. Also, para. MSK Fukan, Learned State Council,
No, your lordship. I am appearing for response number 3, your lordship.
who is free?
AGCL.
AG,
my
AGCL.
friends,
AGCL,
Yes, your lordship.
AGCL.
Learned Standing Council AGCL prays for and is granted 3 weeks time.
Yes, our name may be shown, your lordship. Our name has
Yes,
not been.
to file the affidavit in opposition. Registry to reflect the name of
SC.
MS
SC AGCL.
K Fukan as Standing Council AEGCL in the Congress.
Next step, my lord.
3 weeks.
My lord, notice is deemed to be served, my lord.
Upon
Upon respondent number 2 and 3, my lord.
anybody appearing for 2 and 3? You are appearing for 2 and 3. You'll file affidavit.
We will file it.
In the office note dated 9/9/2022, comma, full stop. The notice upon respondent numbers 2 and 3 is accepted to be served. Full stop. In fact, 3.
A Dhanuka. A Dhanuka.
K.
A Dhanuka.
Hanukkah. Learned Council has already entered appearance for the said respondent numbers 2 and 3. Full stop. Both you would file affidavit, Mr. Sekia? For whom?
4 and 5.
And state respondents? Who's for the state? Who's for the respondent number 1 and 2? One.
Standing Council Finance will appear here.
Finance?
Yes.
Madam, you are for finance? No.
The Gogoi saying may be recorded, your lordship. He's on legs, your lordship.
Mr. Chalia was here some moment ago. We record your name? Oh. What about the affidavit, Nana's filed affidavit? On a prayer made on behalf of the council for the respondents, 3 weeks time is granted to file affidavit in opposition. The further respondent number 1 is represented by B. Gogoi, whereas respondent numbers 4 and 5 are represented by A. Sekia. Time to vote.
May I please, your lordship?
Yes.
Lordship, respondent number 6, that is circle, is our revenue department, had filed an affidavit in opposition, 2 weeks times. Filed a reply.
You'd file rejoinder. Your Talukdar.
P. Talukdar.
On the prayer of MSB Talukdar Learned Council for the petitioners, 3 weeks time is granted to file rejoinder affidavit to the affidavit in opposition of the respondent number 6.
And the best.
Lordship, may kindly take up item 40.
40 reviews by you.
40 is the review petition filed with the state.
Lordship, by this petition, we have preferred a review petition for review of the Honorable Court order dated 20th of June 2022. Lord. That order is at page 21. So, Lord, while adjudicating that writ petition and passing the order, Lord, a vital aspect was, Lord, it was inadvertently, Lord, it was not brought to the notice of the Honorable Court, Lord, at that point of time. So, in fact, Lord, Lordship, may kindly have a look at this Honorable Apex Court decision. Lord.
Has notice gone?
No, Lord, but it's coming for the first time.
First time.
In fact, it was listed earlier, but did not reach. The petitioner, well, in fact, the writ petitioners, they have filed the contempt petitions, they have connected two contempt petitions. In the contempt petition, we mentioned that we have already prepared a review petition, therefore the contempt petitions are tagged here. Lordship, at this stage, you may not need to notice,
We'll try to have the response in the review.
Lordship.
Otherwise, what is the main ground?
The Honorable Apex Court decision, it is reported, I have given a copy.
Yes.
It is 2007-11 SCC 681.
Yes.
The thing is that kindly come to paragraph 20. I'll take two other paragraphs also, but for a moment, kindly come to paragraph 20.
Yes.
The issue is Anganwadi workers, they are not government servant. They are not holding any government servant. But the para 20 Anganwadi workers, however, do not carry any function of the state. They do not hold post under a statute. Their posts are not created. Recruitment rules ordinarily applicable to the employees of the state are not applicable in their case. State is not required to comply with the constitutional scheme of equality as under Article 14 and 16 of the Constitution of India. No process of selection for the purpose of their appointment within the constitutional scheme exists. We do not think that this state decision has any application because they were relying on some other decision. But our contention in the review petition is that the persons, the writ petitioners, they were Anganwadi workers. They were claiming promotion under 25% quota to the post of supervisor. But when they are considered under a particular scheme against the 25% reserved vacancy of supervisors, but that will be their initial entry in the government service. Otherwise, although the word promotion has been used there, in fact, they are not promoted. In fact, for the first time, they are recruited to a government service. They are otherwise holding the post of Anganwadi worker, and those are honorary posts under a particular scheme. Therefore, the payment of salary and the scale pay with effect from the retrospective date, that will not. Our main thing is that from the date when the government has given the concurrence and they were appointed to the post of supervisor, they are appointed.
You are seeking review with regard to which direction?
Kindly, the order starts at page 21.
No, which paragraph?
Lordship.
19.
Paragraph, Lordship.
19 of the judgment.
19,
Please read.
Kindly have a look at para 17.
17.
Para 17.
Yes, please.
It appears that a recruitment process was initiated by communication dated 1/10/2015, wherein the petitioners were amongst the successful Anganwadi workers who were selected for promotion to the post of supervisors. After going through the selection process and being promoted to the post of supervisors, there was no reason as to how the petitioners could not be deprived of substantive appointment and others were given contractual appointment, that too for a fixed period and pay. There is no doubt that the cadre of supervisor is one and the same, and therefore, whether one is appointed directly in the 75% of the vacancies or promoted after selection from Anganwadi worker in the reserved 25% quota cannot make any difference in their service conditions as supervisors. Rather, this court is of the opinion that the cadre of supervisor is a homogeneous one, where the mode of entry into the state cadre would be wholly irrelevant. On a specific query by this court, it has been clarified that there is no difference in the duties discharged by the directly recruited supervisor or one who is promoted from Anganwadi worker. Further, the recruitment process for supervisors, which was initiated by the communication dated 1/10/2015, was only to fill up 25% quota reserved for Anganwadi workers and not for some other post belonging to a different cadre. The Learned State Council has also clarified that on August 2021, there were 924 number of supervisors, out of which 647 were directly recruited, and in the year 2016, 277 number of were promoted from the rank of Anganwadi workers. But this promotion from the Anganwadi workers, what has happened, Madam? There are thousands of Anganwadi workers in the state. But since they are holding an honorarium post, therefore a scheme has been formulated by the government to give them an opportunity for getting job under the
The
government
supervisor.
as supervisor. Therefore, 25% post of supervisor is earmarked for that category of person only. Well, they have to undergo a regular selection process, and according to that selection process, they are recruited as supervisor. Well, although the word used is promoted, in fact, there is no promotion, Madam, because they while holding the post of Anganwadi workers, they are not holding any government post. And their
No,
appointment.
that is not relevant for the purpose of their salaries.
No,
We have said that
it is, Madam, because
since the duties performed by them are the same, there is no difference in the cadre, whether you have entered as an Anganwadi worker or a direct recruitee.
what has happened in that?
Now, can you have a difference?
No, in that case, Madam, what has happened? They were given temporarily. Subsequently, when the finance concurrence has come, because for direct recruitment at the
No,
initial.
for the same set of person, one same duty, you'll pay fixed salary to one set and scale to another,
Because for filling up the.
only because the mode of entry is different.
Well, for the for filling up the post on a regular basis, Madam, the concurrence of finances.
See, we may fully agree with your thing that
Logic.
discharging duties as Anganwadi is more of a service honorarium.
Logic.
But you have created to give them impetus. You have created a service quota of 25%. To be further given an upgradation, let us use the word upgradation, to the post of a supervisor, which is a substantive post.
Logic.
Now there is 75% for direct recruitment,
They are,
25% from the Anganwadi.
because those are.
Now, once you enter into the cadre of supervisors,
Logic.
you become one cadre.
Well, for filling up the post, that 25% post, concurrence of finance for the initial appointment is that financial concurrence in, we receive the concurrence.
No, are you disputing that 25% is not reserved for Anganwadi workers?
It is reserved, but without concurrence.
See, we can take the analogy of the engineering services.
Logic.
To become an assistant engineer, you can be a diploma engineer, have 8 years of some service, then you come into the,
Logic.
and one can be a degree holder and be straight away recruited. But once you are recruited into the cadre, engineering services, then you become a member of the cadre.
But here,
The mode of entry into the service determine the salary.
here, Malad, the concurrence of the finance has been received in the month of August 2021.
And then you should have always said that somebody who enters into the services of supervisor from Anganwadi worker, they'll get less salary. Let them be aware of the service conditions.
From August 2021, they are.
That is not, that cannot be an excuse, that financial condition. Once you receive the concurrence, you have to pay the earlier.
Yes, they are getting. They are
No, even for the period, if they are not discharging their duties as as a supervisor, matter would have been different.
But
Now, if you are admitting, no, yes, they have been appointed as the supervisor,
they were given.
discharging the duties as supervisor. If somebody is getting 10 rupees, why shouldn't he get 10 rupees? Why should he be given 5 rupees?
But, Malad, they were given therefore temporarily at that point of time till the concurrence is received by from the finance.
Temporary nature, would it be dependent, if the salary dependent on some allowance, something can be different, but whether the scale can be different or fixed salary and scale, very difficult to accept.
Malad,
Yes, Mr. Bora, you're for whom?
Lordship, till now, since notices have not been issued, for the first time, I have been appearing in the contempt matter regarding this petition. But for the review, Lordship, I was not the same lawyer. Therefore, Lordship, if Lordship permits, I will just point out that this aspect.
Let us issue notice first, if at all we entertain.
Yes, yes.
let them.
Lordship,
Not now. But for a review exercise, prima facie, you would have to make something exceptional case.
Well, in fact, the status.
Even if we assume that you have some marriage that is going to the marriage, we cannot go into the marriage again.
Malad, we are seeking a review of the matter, Malad, because Malad, at that point of time, the status of the persons who were.
Mr. Potocki, will you appear in this matter? No, in the review. We are not too much inclined in issuing notice, but just to be fair, we may issue a short notice and have this matter sorted out immediately. Do you have instructions to appear? No, I'm asking only because you are the counsel in the main writ petition.
They are the opposite party. They are the opposite.
No,
party.
whether he'll be appearing, that's his discretion. Without instruction, he perhaps,
No, not
you would seek instruction, Mr. Bora, you are for the contempt matter.
contempt.
If we'll not take the contempt, we'll have the review first. And we'll go by the principles of review. We may not enter into the merits. If you make out a case on review, then only we'll enter.
Maybe taken up after 10 days.
Conditions are very till now well settled.
Follow.
Culpable error, something which was not there.
But any other sufficient ground.
But if you are taking this review only to circumvent the
No.
implementation, then will come slightly heavy upon.
No, kindly.
This has been the trend. That just to have some breathing space, you file a review. Then review gets drag 1 year.
No, Malad, we filed the review and we are proceeding.
So we'll have a short notice immediately after the. I heard Sri Dinath, learned senior court advocate, Assam, who has appeared for the state, which is this, for the applicants, for the review applicants. In this petition filed for review of an order dated 26/2022 in WPC 7215/2018. When did you file the review?
We filed the review, Malad.
On 10th of January 2023.
No, Malad.
Yes. 10th of January 2023.
After issuance of contempt notice. That's the thing.
In fact, it was in the month of November.
No.
November 25/11/2022 we filed.
10th of January 2023.
But it was reported possibly on that.
No, not reported. It's fine.
It is 25/11.
Your date will not do. We cannot help.
No, Lordship.
It's the date of, see the records. They have already passed a judgment. Review, if you do not file it in time, even in a writ proceeding, will apply the Spirit of Limitation Act.
No, it was.
See the filings, see this thing, the stamped endorsement in the first page.
First page.
First filing page.
Yes, I have seen the seal. But can you see what the filing number on 25/11?
Filing numbers are not required. There may be some defect. We will go by the date which has been endorsed by the office. Recently, we have dismissed the state's appeal on the ground of limitation.
But there are some defects were there. So it was rectified and thereafter.
Filing and defective is no filing.
No, but
Our court division bench is held. Defective filing is no filing. It will not save limitation.
but the defects are in fact one of the.
We have not said, division bench has said. And this court has held that if you will apply the law of limitation spirit, even in a writ petition. Recently, we have said in the irrigation case. We may be wrong, we may be tested, but that's our view.
We filed on 25/11, but some defect was. because it was notified later.
কি করলো তাৰপিছত? Evidently, the filing date as per the office is 10th of January 2023. Which is beyond the period prescribed for filing a review. First of though, the Limitation Act, per se may not be applicable in a rate proceedings, the spirit of the same is applicable, which is clarified by the by a Constitution bench of the Honorable Supreme Court in the case of so and so. Therefore, keeping the issue of the question of maintainability open, let a notice be issued, returnable on the 8th of May. No, not 8th, 10th of May. 10th May, okay? 10th May. Let steps be taken for service of notice upon the respondents, opposite respondents by registered post with AD. Let's steps be taken by tomorrow, or by today, by within 3 days. You keep a track, Mr. If you are appearing well and good. Mr. Nath, your task will be a difficult one.
Difficult.
You pursue, try to, but ground of limitation will be, since you have already decided in one of the cases. Hmm, 50.
Lordship, in this case, Lordship, this is the cancellation of GST registration. Lordship, last time, on one of the last cases, Lordship, I had informed your Lordship that the order does not contain the reasons for cancellation. Lordship, it is, even though it is covered by Madras High Court that orders must contain reason, should not be supported by SOCO's notice. But Lordship, since the notification has come, I would only request one thing, your Lordship. Lordship, the notification gives me that I should file my returns to the subclause B. Lordship, I'll just give a copy of the notification. This I may fulfill, but Lordship may not relegate me again to the appeal. Lordship is the appellate authority, so I will do this, and Lordship, my it may be revoked. If I do this, if I comply with the clause B, Lordship, my this will be revoked. Again, Lordship, again another round of litigation. This is already a litigation, Lordship. I have gone into many rounds of litigation. Lordship, the B. Only that, Lordship, I will fulfill this.
They lag by this notification. That is what we have been directing.
No, Lordship, if Lordship, if I go by this notification is for those people who have not yet gone into any litigation. Lordship, I am already before your Lordship. And Lordship,
You will not be the primary authority. What are you saying?
Lordship, now the Lordship,
Will explain the primary authority.
Lordship, because NCL,
This
because,
notification is for us.
Lordship, but the notification is not for us. Lordship, notification is those people who have not gone into litigation. I am already before your Lordship, before coming into effect of this litigation.
Yes.
I'm only, Lordship, proposing that this clause B, which is there, I will fulfill this, Lordship. In view of that, it may be revoked. The clause E, which said again, I will apply before the appellate authority for revocation again. Lordship, that may kindly be avoided because Lordship has already disposed of many cases and Lordship, this notification is this effect. I will do this, Lordship. And if I
No,
do
you
this,
will give you a liberty, you can inform them about this notification.
Lordship,
Since your adjudication process is already over,
yes,
we
sir.
may not go by the same rigors, but somebody has to apply this mind on this notification.
Lordship, respondent number 3 may reply. The person who has cancelled my revocation.
He'll act as per this.
Yeah,
We have
that
been
may-
passing
that-
orders.
That
Lordship,
means
We have
we
been
will
passing
agree.
orders, same orders.
That we
Same
will
orders,
agree, Lordship.
Lordship, as per the act, Lordship, the window for them to apply for revocation was already closed. This, a policy decision taken by the GST Council, Lordship, giving them a window till
We will
30th
not
June.
create any exception.
Lordship, after that, my lords have
We
interfered.
are
and-
not creating any
Lordship,
exception.
at least 75, 40, 30, 40 judgments have been passed by your honor itself, Lordship. Similar order has been passed.
We have passed,
I'm
we have
just-
been passing orders,
Yes,
same orders.
Lordship,
we passed.
Lordship have passed order, but after
Lordship.
coming of this
Lordship,
circular,
I will-
Lordship,
I will
they,
comply with
they,
the
are-
circular.
they have been given an opportunity, Lordship. If they don't apply.
Now
it's
you
up
don't
to
need
them.
to, there is no adjudication process in view of this circular. This will go back to you. Otherwise, you need to adjudicate your cases.
Yes, Lordship.
Lordship, it will go back to him only, Lordship, but not to the appellate authority. I'm only saying that it may go back to respondent number 3. That is my only.
Sorry. Yes, next.
Lordship, there cannot be an objection on this, Lordship, at least.
We cannot be inconsistent in our order after the notification has come.
Lordship, at least the notification may be quoted in my order. The notification may be quoted
If
in
you
my
want a
order.
hearing, we'll have hear the matter. Please after 2 months, both the matters.
Lordship, I'm just
Please
proposing.
after 2 months. Yes, next.
Lordship,
Don't Purna, please after a month.
Lordship, I'm just proposing for quotation of this order. That's the only
We are not agreeing with your proposal.
the circular may be quoted, Lordship.
We are not agreeing with your proposal. We'll hear you.
Lordship,
On the
in
merits.
morning also, Lordship has
Then the
ordered
Lordship may pass the same
similar
order.
We're not passing the same order. You have to be consistent with your, it's not a or thing. I'll have this or this.
No, Lordship, I was covered by Madras High Court judgment, which is confirmed by
We'll
Supreme Court.
hear you,
That's only.
we'll give you time, adequate time
Lordship, I
after a
think
month.
23 may, Lordship, which was disposed of the same order may kindly
Sorry.
be passed.
Next. Yes, Mr. Secretary.
This IA was filed for correction of the lordship's order, whereby my lord, does actually mistake on the part of the respondent counsel. My lord, 2 repetitions were taken up by your lordship for disposal. In both the 2 repetitions, my lord, the compensation cases were quoted.
That Gwalpara, Jamindari matter.
My lord.
One we have corrected already, I think.
My lord. Now they have filed an affidavit, my lord.
Yes.
My lord, clarifying the stand that
The numbers were wrongly written.
yes, the cases involved in the present repetition also, my lord.
What is the nature of, what do you say, madam?
Lordship, I have filed a affidavit on 6th of April. It may not be on record, Lordship.
6th of April.
Yes, sir. Lordship,
I think one affidavit is there. Filed by whom?
he has it.
Hmm?
Filed by Deputy Secretary, Lordship, Deputy Secretary. Respondent number 4, Lordship.
It's not there.
Yes.
I have given my comment.
Aanibo laibo na. 6th of April. Let it be here day after tomorrow.
Fine.
Okay. MS G. Hazarika, Leonard, Selling Council, Revenue Department submits that an affidavit in opposition has been filed on 6/4/2023, which however is not tagged with the records. Let this matter be listed on day after tomorrow, date to remember, along with the affidavit that has been filed. Yes, next. I don't think it will take any time.
Not take much time, my lord.
Yes, yes.
Please, Lordship. Lordship, as per office note dated 28/3, Lordship, service is awaited, Lordship, upon respondent number 456, Lordship. Private respondent there.
Notice is issued for on 28/3 only, okay. Office note dated 28/3/2023 reflects that notices have been issued to the respondent numbers 4/02 6 by registered post with AD only on 28/3/2023. await service report.
43 same lordship, official dated 3/4 lordship.
43.
Yes, lordship.
Office note dated 3/4 or 3/4 duita, huh? 4, 5 and 6. You will file affidavit in the meantime?
My instructions are waiting.
Awaited, in the meantime, in the meantime, Pathak, KB Pathak, Standing Council, APDCL may obtain the instructions / file affidavit in opposition.
Obliged.
Your lordship.
Yes.
Hereby the issue involved,
Hmm.
whether the tenure of the board of directors can be extended beyond 5 years or not.
Hmm.
And the last occasion, my lord, respondent, my lord, council has stated, your lordship kindly see the last order 22.
Yes, 22/3.
My lord, that matter has been tagged. But in this, our case, no affidavit has been filed. Our problem is that, my lord, 21 is the last date of our tenure, my lord. That is the main problem, my lord.
Affidavit not necessary. I have made it clear that affidavit will cover this case also. Once your lordship holds, my lord, that they cannot be allowed to function beyond 5 years, then my lord, matter ends there.
That is the issue there, whether this Supreme Court, what has said, stated. Not, I have not seen that judgment also, an affidavit has not been filed in my case also.
Now, let a copy of the
I'll
affidavit
punish him, I'll punish him.
given to
I
you.
will give.
Okay. But we have also held in the case of municipality that your tenure is 5 years. After that, you don't have the mandate of the people.
Yes.
Whether,
Correct.
It is only on the strength of the mandate of the people that they select you for or elect you for 5 years. Mandate is over, you are over.
whether if there is a stay by the honorable court, whether that period will be.
The ad hoc learned counsel for the petitioners submits that though an observation was made that a similar issue is pending consideration in another writ petition, namely WPC 6249/2022, no affidavit in opposition has been filed in this case, full stop. He further submits that he is not aware of as to whether any such opposition has been filed in the other case, namely 6249/2022, full stop. To it alluded, Understanding Council, Cooperation Department, however, clarifies that affidavit in opposition has been filed, has indeed been filed in the other writ petition, WPC 6249/2022, and he undertakes to serve a copy of the same to Sri Hawk as the same point of law is involved. Full stop para. Let this matter. In the other one who is appearing, let both these matters be listed on.
Not, our problem is that after 21, we will be disqualified for next election. If we don't.
We'll have it on 18 then. 18th?
18th is holiday, 19 or 20.
18.
Oh, sorry, not 18th. Sorry, 19th. 19th. 19th.
Item number 45 gives the interim order.
45 interim order passed earlier to continue till the next day of listing. What kind of interim order?
For not holding the election.
Okay.
Let's see.
All right. Bail hearing 9. Oh, we will know.
Lordship, Mr. Deenar will appearing in this matter. Lordship, he is on legs in court number 5. Matter may be passed over for the time. Lord.
Yes, ask him to come.
Okay.
There is so much of contempt also.
Okay.
Yes, what is the position now?
Position, my lord, from the affidavit filed in the contempt case, my lord, it seems, my lord, they have cancelled their temporary settlement. That part.
What is the explanation?
Explanation, my lord, affidavit, my lord, they said, my lord, they could not have understand. That is the laments.
Who has not understood?
The authority, my lord.
Principal
misunderstanding.
Secretary. IS officer.
Yes, my lord, IS or I don't know, my lord, maybe IS officer.
Our orders were written in Greek or Chinese.
Secretary, my lord, If your lordship permit me, I'll just read a small paragraph, my lord.
No, let Mr. Nath come. We'd like to interact with the officer. Madam, our orders are not written in Greek or Chinese. Yes, Mr. Nath, why was it not, why this kind of activities? In direct violation of court's order?
But, Lordship, there was a mistake on the part of the.
Why mistake? Why?
But,
If it is due to lack of communication, we can understand. But if she or he has not understood, then we'll have to like to have an interaction.
kindly, an affidavit has been filed.
We have seen the affidavit.
Because
What has not been understood?
in fact, they said due to wrong understanding of the,
No, what has not been understood? The order has not been understood.
but, he joined the department on 23rd of December. And, when the file was placed before her. But, he has misconstrued that, no third party should be given. That has been misconstrued by her. But, now, the order has been cancelled. And, she has.
Now order has been cancelled only because we had issued so motor notice.
But the unconditional apologies he has given, and this is because of the wrong understanding he has stated.
Not at all convincing. We'll be convinced only if she says or he says, I was not aware, or it was not communicated. Then also we'll not leave her or her. Then also who has not communicated. It is a collective responsibility of you. That is not the defense. Let the officer come. We did not direct person appears on the first day. We thought should not. There may be some explanation which is acceptable. This is not an acceptable.
Kindly give me
If he or she does not understand the court's language, and is he or she fit to be an officer of the government?
That's. Kindly give me some time. Let me go through the record.
No, let her come.
Let
her come. Heard.
Lordship, kindly keep the matter immediately on the reasoning. Let me go through the record.
In a notice of contempt, personal appearance is indicated. We have to say that it is dispensed with. It is normally required. But we do not want an officer to come here leaving her or his work. But in these kind of things, where on the face of it, contempt is there.
The officer has made her unconditional apology.
We are not.
And the explanation has been given. Kindly give me some time. Let me go through the records. What the office from the office records. Let me
On the prayer heard D not on the contempt, you right? Heard 3 D not. Let it counsel for the respondent against whom this proceeding was initiated through motor. Nath has submitted that the affidavit filed on 3rd of April 2023 is on record, in which an unconditional apology has been sought for. Full stop. There is an explanation. The explanation given is that the order of this court could not be properly understood. Full stop. The explanation does not appear to be convincing at all. As convincing at all. Full stop. Para. At this stage, Nath, please for some time to obtain instructions. List after 2 weeks.
In other item, my lord.
We'll have along with this.
55, 57, 59, 60, there is an interim order.
In the other, you write along list after 2 weeks along with contempt case to ensue. Interim orders passed earlier, if any, tense extended till the next date of listing.
Instead of next date, my lord, till the disposal.
No. Let us see.
Plus.
Lordship, item typically contracted counsel is annual. So matter may kindly be, if possible, fix after Bihu.
If it is a past order long time back, you are not here, real matter. We have not dismissed it. We have some date. Okay, it is after behavior. After 1 week.
There is an IA filed by me, my lord.
IA for
IA for impleading.
implement.
There was a tender process. My lord, I have also, I know, my lord, it's not permitted or possible, but still, given the fact situation, I have prayed for a clarification of my lord's order.
Who are you?
I'm a tenderer, I'm a bidder. What had happened here was, my lord, there was a tender published.
No, has he raised any issues against any third party?
But what happened was,
We are not going to hear you.
no, my lord, I'm not
Sorry.
third party. I'm not third party. Why, how I am affected?
Has any allegation been made against you?
My lord, there were two groups here. One is hybrid maize and one is biotech maize. He had, in terms of the liberty granted by my lord, applied for hybrid maize.
One.
The other one, because of the order passed, the other one is also now stalled, wherein, my lord, I am also a tenderer.
That much we can
I know
clarify
there are
after
further
hearing, of course,
developments. And I have
Mr.
got to know today, there are further developments, my lord, which my senior would place before your lordship. The whole work, the director now is trying to give it to some others without it already given to some others. I've got the copies without, my lord, even honoring this honorable court's order. This today morning I came to learn from my friend that my senior will place
You're for whom?
with me.
And Mr. Bora, Ms. Bora? Now, what is happening actually?
My lord, I think time has come, my lord. Some stand view has to be taken. What had happened, my lord?
Now, first we'll clarify if Mr. Nair is correct in narrating or there is no dispute with the facts that he did for another thing which you are not interested on. Then we can, so far as he is concerned, we can make it free. If you are not a bidder in his item, then we can clarify that. Without disturbing your interim order.
The hybrid maize, my lord will consider his case, my lord.
Only thing is, my lord, lordships will not clarify the order.
No, not at all. Only thing is that we'll say that so far as two parts are concerned, this case
Hybrid.
is pertaining only to the hybrid thing.
Yes.
Lordship.
Hybrid.
And what is your instructions?
Right to place.
Yes, where is Mr. Chaudhary?
My lord will hear my senior on the other aspect, what he has done, because that will also affect me, my lord. My lord will just have my seniors, my lord.
My lord will kindly come to order dated 24.
Which one?
In WPC 1732, my lord.
The second one.
Yes.
Yes.
The contention of the first para, contention of the petitioner is that in respect of the NIT in question, challenging certain clauses, including the clause in question, present petition has earlier filed WPC number so and so. This court-wide order dated 10/2/23, while issuing notice had passed an interim order to the following effect. Considering the nature of the supply, this court is not inclined to stay the proceedings. However, it is directed that without prejudice to the rights of either of the parties, petitioner may be allowed to submit his bid, which however would be subject to further order that may be passed by this court. It is made clear that participation in the tender process shall not waste any right on the petitioner unless a case is able to be made out. It is the case of the petitioner that on the strength of the aforesaid interim order, he submitted his bid. It is also an admitted fact that the said writ petition till now, department has neither filed any affidavit in opposition nor any application for vacating stay. However, by the impugned decision, rejection has been done by taking recourse to a clause which is the subject matter of the pending writ petition. The aforesaid action prima facie appears to be grossly illegal and in the teeth of the earlier observation made by this court. This court is also intrigued by the fact that when court is in session of the matter, wherein interim direction has been passed to balance the equities, an action can be taken to cause prejudice to a party to the lease on a ground which is already under challenge in the pending lease and circumvent the interim order. At this stage, Mr. B. Chaudhary, Learned Standing Counsel Agriculture, submits that earlier writ petition can be taken up for disposal expeditiously and suggests that date may be fixed on 29/3/23. It is up to the department to file its pleading before the next day. After hearing, it is made clear that no work order should be given in respect of the order in question. And if in the meantime, such work order has been issued, no work should be allowed to be proceeded with the strength of such work order. My lord, despite your lordship's order dated 24/3/23, my lord, work order has been issued on my lord, on my lord 6/4/23. And interestingly, my lord, I have also been given a work of 1 crore. If I am ineligible, how you are giving me work? And the director says, kuch nahi hoga. By 17, make this apply or else we'll blacklist you. Court kuch nahi kar sakta hai. I'm making this statement with all sense of responsibility.
And my lord, now I have taken information, this is fact. We were not knowing, but after getting this.
My lord, it reminds me of one thing, my lord. Lordship would recollect, there was a time in Hindi cinema, Ajit was a very famous villain. Then, my lord, West Indies at the relevant point of time toured India. First 2 tests, India lost. Third test was Calcutta, which India owned. Madras also India owned. And fifth test, Madras was India. Anyway, that series India owned. Then, my lord, Pataudi was the captain. Then Pataudi was in big trouble. So what he did, he went to my lord Ajit. Then he said, we are in trouble, what to do? Then Ajit gave a suggestion, my lord. Vishwanath ball karega and hamara aadmi sleeps mein rahega. Vishwanath of all person will ball and hamara aadmi sleeps mein rahega. This type of actions are being taken. My lord, I cannot say few things. My lord, they are not showing any respect to the authority of the. I can say only that much. Now, in this case, my lord, they have made a shortlisted few candidates. Sorry, few parties. My lord, we have filed an additional affidavit to show how, my lord, they have flouted the order. For example, my lord, one party called Salasa. My lord, what he has done, he has given a financial soundness certificate of 2 crore. Now, that has been construed as, my lord, annual turnover for the last year. In a party, my lord, he doesn't have a seed license. He has been, my lord, I have instructions to submit. My lord, many parties who are not even eligible, who have not bidded, they have got the vote. My lord, these are all fast going on, my lord. Please call for the record and find out, man, whether what we are saying is correct. Time has come, my lord. Some officers should be taken to task. Otherwise, my lord, this put a free run is going. All sense of responsibility, I am making this submission. My lord, I have filed an additional affidavit wherein I have brought on record all these allegations. My lord, when there is a stay order, I do not know, my lord, nowadays how government advocate operates. My lord, there was a time I also appeared on that side. But I never encouraged all these things. Stay order means stay order. Either you file a vacating stay order, then you do whatever it is. It's nothing like karo, hum log dekh lenge. This is not good. My lord, it's a prima facie.
You are correct. Many stay orders are getting vacated. Please, and I.
My lord, we all know these are seat supply. These are kind
on expert basis. There may not be many things which are not within our knowledge. We come across the IA and many stay orders we vacate it.
Yes, certainly.
And if you don't vacate, DB is there.
DB is there.
You can test the.
Kindly see when your lordship is in session.
Something serious is going on.
My friend told me, if that is true, lordship, I don't have the instruction, then lordship lordship will have to interfere.
And my lord, at least they will
have the records.
Yes.
I think that
and they will not release any payment, my lord.
Apply the one,
No supply, no payment. If supply made, no payment. My lord, in the name of seeds, they cannot do something which is, my lord, atrociously illegal.
Lordship, after lordship passing of order in court, the writ petition. I have already communicated, but if that is happening,
this official called Gyani.
Anand Lal Gyani.
Anant Lal Gyani.
Gyani. He's really Gyani.
I think lordship can take so much of time, my lord.
Let us see the records. Day after tomorrow?
Yes. And my lord will restrict them because otherwise my right, my lord, will be there. Although my lord, by the order I am protected.
Where is your IA?
My lord, my IA is.
Your Pranam Deka?
975, my lord.
Your Pranam Deka?
Pranam Deka, my lord.
You can add senior counsel for the applicant who
hearing of
by this application. Six.
As an officer of court. Well, prayer is that page. number. Better to change.
Six, implement as party respondent
Number 5.
as well as clarification of the order dated 24/3/2023 passed in WPC 1732/2023. The case of the applicant is that though the subject matter of the connected writ petition is a tender process for various items, the writ petitioner is based his challenge, is aggrieved for the, what is that thing called?
My lord, I am for writ petitioner is hybrid means. my lord.
The challenge of the writ petitioner is connected with hybrid.
He has submitted his bid for hybrid means.
Hybrid.
Hybrid
Maize.
means.
Maize. Whereas the applicant in the instant case is a bidder for,
My lord, hybrid means plus, my lord, bio fortified.
that's a different item.
That's a different item. Bio fortified means. my lord.
For hybrid maize as well as for bio-fortified maize.
Actually, he's applicant for both.
Both.
Yes, I said, we will maintain it for hybrid.
My lord will maintain it for hybrid. my lord.
The senior counsel submits that since there is no challenge for the item
Bio fortified. Fortified
bio-fortified maize,
means.
The interim order passed by this court on 24/3/2023 is causing prejudice to him. Full stop. Also heard free, K. Chaudhary, Learned Senior Counsel for the opposite party, writ petitioner, full stop. Shri Chaudhary has clearly submitted that the order passed on 24/3/2023 may be clarified to the aspect that the ambit of challenge is only confined to the hybrid maize and not for the bio-fortified maize.
Hybrid means. It's bio fortified hybrid means.
Bio-fortified hybrid
Hybrid
maize.
maize. Different item.
Also heard Shri P. Chaudhary, council, Senate council for the agriculture department. After hearing the party, after hearing the party, this court is the opinion that a case for implement as well as clarification of the order dated 24/3/2023 is made out. Full stop. Accordingly, the IA stands allowed by arraying the applicant
So that's one number 5.
as respondent number 5.
Six, my lord. Sorry, 6.
Six.
It will be, my
You have
lord.
written it 5 here.
It will be 5, madam. Sorry, 5.
Respondent number 5.
5.
It is further clarified that the interim order, that the interim directions contained in the order dated
My lord
24.
may pass this order day after tomorrow. And he is also not agreeing on that. Day after tomorrow. after
Otherwise,
the
my lord will only stay the other process, my lord.
No,
This will not make any difference, my lord. My lord, can-
We'll maintain the stay so far as your.
Hybrid.
Hybrid,
is
huh?
going
Hybrid,
to-
huh?
No, my lord, they have already issued order even for bio 45.
Everything they have issued, my lord. That
That's
will
what
also
I'm
have to be
saying.
stayed, my lord.
That's why I'm saying, my lord, this part lawsuit will pass on Wednesday. Implement part is okay.
I stand allowed, the last Kumar, in view of the above, so far as the prayer for implement is made, stands allowed, and the applicant is directed to be arrayed as respondent number 5.
5, my lord.
The prayer for clarification of the order dated 24/3/2023 would be reconsidered on the next date fixed.
That is there.
That is, i.e., day after tomorrow, huh?
And my lord,
In the main writ petition, you write In 173/2020, this court has been, Sri Ken Chaudhary, senior counsel for the petitioner, has informed that there are certain developments, including some actions which are in violation of the order of this court, full stop. Sri B. Chaudhary, standing counsel, Agriculture Department, however, submits that he is not aware of the same. Full stop. In that view of the matter, this court is of the opinion that the records of the case would be necessary to be perused. Full stop. Call for the records. List on day after tomorrow.
My lord, the orders issued pertaining
for production of records.
And my lord, the orders issued pertaining to the, my lord, the seeds which are put to advertisement, both hybrid and fortified. That will not, because they have already issued the orders.
Stands extended till the next day of listing.
My lord will make an observation. Otherwise, my lord, they might make the supplies by tomorrow, my lord.
One day supply is not going to.
My lord, there, that's the.
Then we'll say something else.
Lordship.
Let us have a look at the records.
Lordship.
If it is in violation of the course, I will say something else.
Yes.
It will be extracted from the officer.
Yes.
He'll pay from his pocket.
Lordship.
Keep them. Keep them.
No, I don't do it.
32 Kunas. So Gogo is not here. Day after tomorrow, along with her. Sri P. Sharma, Learned Counsel for the petitioner is present. Nan is present for the respondents in spite of names being shown in the cause list. Full stop. In the interest of justice, list again on not 12. That's a readable. 12.
After viewed.
List on 19th. High level.